And hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you enjoy this legal education commentary, and today will be the day I earn that subscription. For today's story, we are dealing with Amber Heard's appeal brief. Amber Heard herself, of course, has filed a brief in her own case, and we are going to review that today. So far, we have reviewed two amici, friends of the court who have filed and have said they know. Tin Can Audio? After all that, really? What's the audio? It's really that bad? Oh, let's try that. Sorry. Should be fine now. I apologize. Anyways, drama over here as we try to figure out how to make things work. Great. Anyways, we're doing Amber Heard's brief today. Sorry for the small technical difficulties as we had problems there as I've tried to figure out how to make my audio work despite limitations here, which leads to a video and an audio channel separately. Thank you very much. All right. So in any case, we are here to review the brief from Amber Heard. So far, we've reviewed two amici brief, two friends of the court. I appreciate that, A-Hanger. So far, we've reviewed two amici, two friends of the court, who have provided their thoughts. One of them was pretty crap because it just blamed the jury and said the jury was stupid and didn't know things, and we know things and facts and stuff, and no. And the other one had some legal stuff in there, although they seem to be arguing out of both sides of their mouth on whether or not abuse was a matter of opinion or a matter of fact. Because they seem to kind of wanted to have it both ways. And they even sort of said that they wanted it both ways, which you can't really do in an appeal brief. You can sometimes plead sometimes you can plead multiply inconsistent facts in a complaint. When you do that, it's called mutually inconsistent pleading. Different states have different rules about it. The federal government has different rules about it. But you can, in some jurisdictions, make a complaint that has two mutually inconsistent causes of action. The one necessarily defeats the other. The reason you can do this, by the way, in the complaint is because you're not necessarily sure which is true, right? You have some basis to believe it's possible, or more than merely possible, but has a bare minimum probability. Both have a bare minimum probability. They can't both be true at the same time, but you believe both have a bare minimum probability. So the idea is, of course, as you come on, one or the other is going to get dropped along the way, and that's a lot of what discovery is for. So you can have mutually inconsistent pleadings because it preserves your options. But that's on a pleading, right, at a very early stage of litigation where you can do that. Here we're not at a pleading. Here we're on appeal, right? The facts are known. We had the trial and everything. There's no longer any sort of doubt about what the facts are. That's sort of what trials are for. And on appeal, we're just here on pure law. And so when they sort of said, okay, maybe abuse is a fact, or maybe it's opinion, or maybe it's both, it's like, But there was some good stuff in there. There was some good stuff, and it was well written, particularly if you take it from the point of view of a person who's writing not much on anything, or doesn't have much to work with, rather. So if you take it from the point of view of an attorney who's trying very hard to represent their client, and they don't have much to work with, I thought it was actually pretty well written in parts, even though they tried to be a little too cute by half on the whole abuse thing, which was a problem. But otherwise, I thought had some good writing skills. So if you're interested in legal writing, particularly on writing in an inferior position when things are looking bad, that second brief is not actually a bad way to look at it and learn something that might be of value to you. But today we're here on Amber Heard's brief, which hopefully will be the best of them all. Hopefully will be the best of them all. And we're going to review it and try to discuss this and see what she has and see what legal arguments she has and see if they're any good, and try to give, as much credit to them as we can see what points that there might be, things that the appeal court might potentially latch onto. We'll try to steelman this as best we can and try to see what we have for Amber Heard's appeal. All right, great. So let's do all those things. And I need to add my own self back to the stream or the window. show. Great. Fantastic. Okay, now you get me picture in picture with the appeal brief on screen at the same time. It's exciting and fun. All right, so let's do that all together. And I appreciate you bearing with me through the many technical difficulties I have. I am still on traveling, and so we do what we can. All right, so this is the brief of Amber Heard. Fine. So we have a table of contents. We have a whole bunch of things we're going to try to argue. So let's see what we can do. We have our table of authorities, all the cases and all other sort of external authorities we're citing. So court cases, legal dictionaries, newspapers, whatever it is we're citing, a link to all those stuff. So the court knows what to look at. Only one citation to New York Times versus Sullivan. That's interesting. Only appears once? Okay. Okay, scrolling. Some various statutes, some various rules. SAC on defamation, that is, SAC would be a treatise. So that's what that is. It's a person who's compiled a summary of the law. So I'm not familiar with that particular treatise. I usually use the restatement, but okay, that's what they're using. The First Amendment to the Constitution, that's always good. All right, so let's see what the statement of the case is. Okay. This apparently is 56 pages. We'll see how it goes. In 2016, applicant Amber Heard obtained a domestic violence temporary restraining order against her then husband, Johnny Depp. 2 years later, Heard authored an opinion piece ultimately published by the Washington Post in which she discussed the public backlash she had experienced after that legal proceeding and advocated for policy changes to support women who report gender-based violence. Support women, incidentally, not support people, but okay. Heard took great care not to mention Depp or repeat her prior allegations of abuse, but, it might have been by reference. But Depp sued Heard for defamation, claiming she had revived her 2006 allegation merely by describing the reaction to them. That's sort of Depp's idea, yes. Instead of suing Heard in California, where both parties lived and where Depp claimed to have suffered reputational harm, California would definitely be a valid place. Depp sued in Virginia, a wholly inconvenient forum with no connection to Depp or any meaningful connection to his claims. Well, is it a valid place to sue? An inconvenient forum is definitely an argument you can make, but I can't think of any time ever an appellate court has reversed on inconvenient forum. I'm sure it's happened somewhere sometime, but if the trial court says, we're cool because we can get all the things here, unless it's, again, you're looking like abuse of discretion standard, so unless it's manifestly unreasonable, So forum of nonconvenience is definitely, it's a trial argument, but not so great for the appeal. The trial court erroneously refused to dismiss this action on ground of forum nonconvenience based on the mistaken conclusion that Depp's claims arose in Virginia because the servers are there. Yeah. The trial court also erred in overruling Heard's demurrer, which is a motion to dismiss, in which she argued the challenge statements are non-actionable expressions of opinion and are not reasonable, capable of conveying the alleged defamatory implication. That holding, if allowed to stand, will undoubtedly have a chilling effect on other women who wish to speak out about abuse involving powerful men. This case should have never gone to trial because another court had already concluded that Depp abused Heard on multiple occasions. After Depp filed this case, the United Kingdom High Court of Justice ruled in a separate defamation action brought by Depp that Heard's abuse allegations were true. The trial court should be given preclusive effect to that 129-page decision, which followed a 3-week trial in which Depp, Heard, and 124 other witnesses testified. Yeah, maybe, again, at the trial level, but Now you have a jury's verdict, and you're going to try to say comedy after the trial already happened. That seems like a problem, but we'll try to read it and see what we can do. Once the case did go to trial, Depp failed as a matter of law to meet his burden to prove actual malice by clear and convincing evidence in two ways. First, he did not demonstrate that Heard was aware of, intended to communicate the alleged defamatory implication that he abused her. Well, on the stand, she said it was about Johnny Depp. So there was that. Second, he did not establish that Heard knew the alleged implication was false or subjectively entertained serious doubts about it. I'm not so sure about that. I think he did. The Amber Heard's credibility was sufficiently brought into question in the trial. The trial court erred and declined to set aside the jury verdict and entered a judgment in Heard's favor. As the 6-week trial unfolded, the trial court made numerous evidentiary errors that severely prejudiced Heard, both by excluding highly probative evidence and by omitting irrelevant and prejudicial evidence. Okay, I mean, again, you're going to have a tough time unless it's really, really bad or a lot of it. You're entitled to a fair trial, not a perfect trial, as Legal Bites said. So unless it's really, really bad or there's a lot of it, you're going to have a tough time. The trial court further erred by not dismissing one of the challenge statements because undisputed evidence showed that Heard simply did not publish it. The trial court then refused to hear Heard's proposed jury instruction on communicative intent prong of actual malice. Okay. We'll consider their instruction on it, I suppose. The jury was asked to find it, but not given a specific instruction on it, so, all right. Consequently, the jury instructions were missing a key element of establishing defamation by implication. In addition, the resulting jury verdict against Heard on all Depp's claims cannot be reconciled with the jury's verdict against Depp on Heard's counterclaim. Yes, they can. To find in favor of Depp, the jury must have concluded that Depp did not abuse Heard and that Heard knowingly lied in accusing him of abuse. But to find in favor of Heard, the jury must have concluded that Heard told him the truth about being a victim of domestic abuse by Depp. Accordingly, the verdict against Heard cannot stand. For what it's worth, also incidentally, different jurisdictions have different rules when it comes to mutually inconsistent verdicts. So we talked about mutually inconsistent pleadings, like how you can plead more than one thing at the same time. And it's like not that big a deal because you're relatively early on in the case. Well, as a matter of federal law and a matter of many states' laws, you can have mutually inconsistent verdicts too. I don't know exactly what Virginia's law is. Maybe they will tell me. But the most frequent way this can come up, or the only way I know it practically comes up, is for a felony murder. You occasionally you see a jury come back with a guilty verdict on the felony murder, but without coming back with a guilty verdict on the underlying felony, right? So we find felony murder, but we don't find the underlying felony. That's a mutually inconsistent verdict, right? Felony murder requires the felony. So the jury says guilty on felony murder, but not guilty on the felony. So what do? That's a mutually inconsistent verdict, right? Well, the Supreme Court says this is fine. And many states say this is fine. The reason, by the way, the Supreme Court says it is because, well, we don't know where the error is. And the jury, we don't know if the jury was just being merciful on one count, or we don't know if it was part of a compromise discussion. We don't know how each and every charge is distinct. And so even though these two charges or these two results seem inconsistent, well, they might be inconsistent with each other, but we're not sure which is inconsistent with which. And the jury might have had a compromise or might have had a discussion. And, so we're just going to let the inconsistency stand. So that can be a thing that happens. You can have mutually inconsistent verdicts in addition to mutually inconsistent pleadings. I don't know how Virginia, as a matter of its state law, treats that, but You can sometimes see that in a criminal case, and I would imagine civil cases too. So we'll see how that goes on. So maybe Virginia will say it's totally not a problem that they're inconsistent with each other, although they're totally not. They can be logically squared with each other. These two verdicts can be logically squared because the statement that Waldman made was much more specific. And so they could have found it false for a variety of reasons that don't implicate the other statements. They're not necessarily mutually exclusive. You can reconcile the two statements. But finally, if this court were to disagree with all the foregoing, the jury's award of $10 million and $5 million in punitive is clearly excessive given the narrow time frame for which they could recover. Well, I don't know about that. I mean, it's a narrow time frame, but time frame is only part of the picture, right? Johnny Depp is a fairly notable person with fairly lucrative opportunities. So what would happen for him in a year and what would happen for me in a year are two very different things. So trying to make me whole for a year's wages lost and trying to make him whole for a year's wages lost, would be two different propositions. Or me for a month and him for a month are two different propositions. So the time is certainly a factor, but it could be a day and we'd still be talking about potentially serious cash awards, right? Because of the nature of Johnny Depp's work. All right, so assignments of error, we can skip all the assignments of error. That's fine. This is just telling me all the things that they think is wrong. But we'll get to that in the actual, those are conclusions. Right? Those are the errors. I don't need to know them because they're conclusory to the extent that they're going to be developed. They'll be developed and we'll cover them anyway, so there's no reason to talk about them now. All right, so let's talk a little bit about the facts. Depp and Heard are actors who first met in 2009. They married in 2015, but their marriage was short-lived. In May 2016, Heard filed for divorce and for domestic violence temporary restraining order against Depp in Los Angeles. In support, she submitted a declaration describing Depp's temper, paranoia, and substance abuse. Heard also alleged that Depp grabbed and pushed her, threw the cell phone at her face, pulled her hair, smashed wine bottles in her vicinity, destroyed personal property, and threatened her. After a hearing, the court granted the restraining order. According to Depp, he lost nothing less than everything from the second Heard applied for the restraining order in 2016. Not Sergej, that's exactly what he said. And even if he had lost everything up to that point, it still wouldn't speak to damages from 2016. Even if he meant I lost everything I had the moment she filed it, that wouldn't preclude him from gaining more in the future, to which this defamation could further attack him. I don't think that's what he said, and even if it is what he said, it doesn't preclude the results. The accusations were widely reported in the media, and Depp quickly became associated with them. Once the divorce became final in 2017, the parties issued a joint statement confirming neither party has made false accusations for financial gain. Yeah. That is what they said, but the jury can disagree with it, right? The jury can disagree with that. It's like, yeah, we don't think that's true. Because the jury's the finder of fact, right? I say it's a fact, you say it's a fact. What does the jury say, right? So, just because we both agree doesn't necessarily compel the fact finder or the finder of law. It happens occasionally even for legal things, like both parties join in a motion and the court's still like, nah. Because they're like, they're not doing that. Okay. Depp's lawsuit against The Sun. A British newspaper, The Sun, calling it a newspaper is very generous, but okay, published an article on April the 27th, 2018 that referred to Depp as a wife beater. On June the 13th, 2018, Depp sued The Sun for libel in the United Kingdom. He alleged the Sun article had caused serious harm to his personal, professional reputation. The Sun asserted defense of truth, contending Depp had beaten Heard. Oh, let me fix this so it stops doing that. Thank you. The parties in the UK proceeding engaged in full discovery. Well, that's debatable. Culminating in a 3-week trial with 26 witnesses in July 2020, although not a party. That's kind of important. Heard was an active participant, providing evidence and 7 witness statements. Stop doing that where it just goes from one page to another. It's in there somewhere. Enable scrolling. Great. Thanks. Testified. Depp had access to 16 months of discovery in this litigation, in which he used the UK proceeding on November the 2nd of 2020. The UK court issued a 129-page decision dismissing Depp's claims against the Sun on the basis that Heard's prior allegations of abuse were true. Specifically, the UK court found sufficient evidence to establish at least 12 incidences of abuse had occurred. By March the 31st, thank you, Secret McSquirrel. On March the 31st, Depp had exhausted his appeal, leaving the UK decision in place. In late 2018, while the UK proceeding was pending, the American Civil Liberties Union invited her to serve as an ambassador on women's rights and proposed that she authored an op-ed advocating for policy changes to protect women of gender-based violence. They were expecting a donation in exchange for that, but the ACLU says that they feel like they're all good. Lol. The Washington Post published an op-ed on its website on December 18, 2018, and in print on December 19th. Heard then posted a link to the online version from her personal Twitter account. That's a kind of a key thing there. On March the 31st, 2019, Depp filed this action alleging although the op-ed never identified him by name, it revived the domestic abuse allegations Heard had made in seeking the restraining order. 2 years ago, Depp based his claims on 3 statements. The headline for the online version, Amber Heard, I spoke up against sexual violence and faced her culture's wrath. That has to change. 2, then 2 years ago, I became a public figure representing domestic violence, abuse, and felt the full force of our culture's wrath for women who speak out because of how you spoke out 2 years ago. What did you say 2 years ago, right? And, and 3, I had the rare vantage point of seeing in real time how institutions protect men accused of abuse. Whatever she could be referring to, right? Heard initially moved to dismiss on grounds of forms nonconvenience, which the trial court denied. Heard then filed a demurrer, which is the motion to dismiss, seeking dismissal of all claims, arguing the challenge statements were not actionable as defamation by implication, and all but one were expressions of non-actionable opinion. Trial court overruled the motion to dismiss in relevant part. On August the 10th, Heard filed counterclaims, including defamations arising from 3 statements made by Depp's attorney. We've covered that in Depp's appeal brief. I think he's got it. Issue 1 is best issue. Issues 2 and 3 kind of suck. Issue 4 kind of works as a reserve issue to issue 1. But I think Depp's got it. We'll see how Amber Heard's issues do. On April the 13th, while the parties were engaged in discovery, Heard filed a supplemental plea at bar in the UK judgment, having become final, arguing that Depp should be precluded from relitigating the UK court's filing because of her domestic abuse accusations were true. The trial court overruled in part. All right. The trial. On April the 11th, the case proceeded to a 6-week trial. 7 weeks if you include the intermission. Was that April? Was it really so long ago? It doesn't seem that long ago. But okay, I'll take their word for it. Notwithstanding the Depp focused on the attacking Heard's credibility, portraying her as a liar. Yeah, that's. The court precluded her from introducing documents and other evidence corroborating her accusations. A lot of them were from her and were hearsay. And allowing Depp to admit irrelevant and unduly prejudicial evidence that he further used to attack Heard's character. Unduly prejudicial, like Rule 403, unduly prejudicial? Good luck. right? Substantially more prejudicial than probative. Again, you're talking about the judge's discretion, and you want to say, oh, it was substantially more prejudicial probative, and the judge admitting it was abuse of discretion in view of that standard. Good luck. Irrelevant? Not unless it's bigger, there's a lot of it, man. Not unless there's bigger, it's a lot of it. At the close of Depp's case, Heard filed a motion to strike, which is a motion for summary judgment or a motion to dismiss or a motion for directed verdict, which the trial court denied. On June the 1st, the jury returned a verdict in favor of Depp on all claims. In favor of Heard on one of her counterclaims, the jury awarded $10 million to Depp and $5 million in punitive, which the trial court reduced by law, and awarded her $2 million. I wouldn't count on that $2 million. On July the 1st, Heard filed post-trial motions on a number of grounds, which the trial court denied without argument or opinion. I think the trial court had already was like, yeah, we're good. Just denied. That's the best part about it being a judge sometimes. Just be like, no. What's your explanation? None. And what's nice as the appellate court is then you just like, well, since the judge didn't explain her reasons, we're just going to assume any reasons that work. Because again, like the trial court, we give a lot of deference, right, on abuse of discretion standard. So if the court doesn't explain her reasons, that's like, oh, that's okay. We'll just make up reasons. Any reasons will be fine as long as they work. Yeah, that's not a bad position to be in if you're the trial court. It's like, yeah, we'll just make up something. That's fine. That must have been your reason. Sure. All right, so now we're getting into argument finally on this thing. The trial court erred by not dismissing Depp's claims prior to trial. For 4 independent reasons, the trial court should dismiss this action prior to trial. Okay, let's give this a shot. The trial court should have dismissed Depp's claim on the ground of forum nonconvenient. Okay. The case should have never been tried in Virginia. The record overwhelmingly demonstrates Virginia had no meaningful connection to Depp's claim, and California was the only appropriate venue. I'm not sure that's a forum nonconvenience argument. That's a venue or jurisdiction argument. All right, forum nonconvenient is an idea that there's a difference between jurisdictions, venue, and forums. And so, like, the idea is there's more than one place, more than one forum, and it shouldn't be this forum because all the evidence is in another place typically, or all the facts are in another place. So, this court technically has a tie. It's not the best place for it, and you can sometimes see this. You can even sometimes see this happen in international disputes. So occasionally, you'll see a case, even one filed in the United States, and usually in federal court. And sometimes you'll see the federal court say, this is forum nonconvenience, and this case should go to France, for example. There are cases like that where it's like, yeah, this is not, the United States is technically under the rules, technically a valid place, but everything is in even another country, so, send it over there. That happens. But that's a matter for the court to weigh. Once the trial's already happened, trying to reverse on that? I don't know, man. I'm not sure if that's happened. I mean, it must have happened sometime, somewhere, right? But the trial court erred in denying the motion to dismiss, and Depp's claim should be dismissed without prejudice. Okay. Virginia forum's nonconvenience states a trial court for good cause shown. When it says permits, what does it mean by permits? Let's look it up. What is the wording? All right. Okay. Let me show you the statute, and let me show you why this is a problem. And let me show you the key word. I'm going to read this the way they wrote it, and then I'm going to read you the statute, and you get to play lawyer. You get to play lawyer. What is the key thing they left out of this that shows you what the problem is? All right. So here's what they wrote. Virginia Forum's non-convenience statute permits a trial court, for good cause shown, to dismiss an action brought by a person who is not a resident of the Commonwealth without prejudice, if the cause of action arose outside of the Commonwealth, and if the court determines that more convenient forum within the jurisdiction of the parties is available in a jurisdiction other than the Commonwealth, citing the code. All right, so that's what they wrote. Now you get to play along at home with Uncivil Law. And you get to play along and say, what is the thing that they left out that helps to understand why this might be a problem for them. Okay. Hold on. I will get this done. Oh, okay. Okay, so here is the law of Virginia. I'm going to read this to you, and you get to play Spot the Key. Change of venue by a court. In addition to the provisions of some statute, and notwithstanding the provisions of other statutes, the court, wherein an action is commenced, may, upon motion by any party and for good cause shown, dismiss an action brought by a person who is not a resident of the Commonwealth without prejudice, under such conditions as the court deems appropriate, if the cause of action arose outside the Commonwealth, and the court determines there's a more convenient forum for which the jurisdiction over all parties is available in a jurisdiction other than the Commonwealth, or transfer the action to any fair and convenient forum having jurisdiction within the Commonwealth. Did you spot it? Did you spot the key word in the sentence? The key word? I'll highlight it for you. In addition to the provisions, and notwithstanding the provisions of some other stuff, the court wherein an action is commenced may, upon motion and for good cause shown. May, upon motion by any party and for good cause shown. Not shall, may. Yeah. And that would be the thing. The trial court's decision is reviewed for abuse of discretion. Good effing luck. Good effing luck. A court abuses its discretion when it makes an error of law, but it's not an error of law. It's not an error of law because what is the key word? What is the key word? May. Here, the trial court made an error of law in concluding that Depp's defamation claims arose in Virginia rather than outside the Commonwealth. Had the trial court correctly applied the law in this regard, it would then have been required to consider whether a more convenient forum within the jurisdiction of both parties were available. The evidence before the trial court clearly demonstrates that California was such a jurisdiction. It may be a valid jurisdiction. In fact, I know it's a valid jurisdiction because the defendant lives there. So it's necessarily a valid jurisdiction. But it doesn't mean it's the only one. The evidence before a trial court clearly demonstrates, well, I mean, yes, because by necessity, but because of its erroneous legal conclusion, the trial court never even considered the substantial inconvenience and prejudice that litigating in Virginia would impose on her. I'm dubious, and now the trial's already happened, so you'd have to show that prejudice actually manifested in reality. So good luck. Depp's defamation claims arise out of Virginia. The trial court ruled that Depp's defamation claims arose in Virginia solely because the Washington Post uploaded the op-ed to the internet via computer servers located in Springfield. That ruling is inconsistent with Virginia law as applied to internet publications, which dictates that Depp's claims arose in California. All right. Virginia adheres to the rule of lex loci delicti, or place of wrong, to determine where a tort of cause of action arises. Fine. For defamation claims, Virginia courts have defined the place of wrong as the state in which the content at issue was published. Neither Virginia Supreme Court nor this court, however, have considered how that rule applies to defamation claims based on internet publications which reach an audience in multiple states simultaneously. So if there's no case law on point, then I guess we could create some, but it would be very weird for the trial court to just create it out of nowhere. I mean, they kind of can, but that's not really the most conservative thing for them to do. Trial courts are about facts, not really law. So trial courts can and sometimes do invent new law out of nowhere, but sometimes they just preserve things for a court of appeals because it's like, well, you know, on the one hand, I could say it happened here, in which case the trial happens. On the other hand, I can say it didn't happen here, in which case the trial doesn't happen. But the court of appeals disagrees with me. They can just say the trial goes away. So the most conservative option in some sense is me to have the trial, because then they can just throw it out and, you know, we've already done that. So, I mean, it's a little bit hard to say the judge abused their discretion when it says may and there's no case law on point. That's a tough argument. They abused their discretion in a statute that says may when there is no controlling case law on point. Okay, that's an interesting argument. Good luck again with that one. The trial court incorrectly concluded that publication for the purpose of online multiple jurisdiction case occurs where defamation statement is uploaded to the internet. And then it says, contrary to under Virginia law, a statement is not considered to be published until it's seen or heard by a third party. Uploading content to the internet is not enough to constitute the complete tort of defamation. Instead, the third party must also receive and understand the content. Because the op-ed reached readers everywhere at once, the trial court finds no basis to find it was published in Virginia, rather than California or elsewhere. Well, let's take a look at this Noonan's case, because I'm interested in this case. This is going to take a while, guys, because we might do some legal research along the way. Okay. Now, I don't actually have to do any legal research along the way for one critical reason. Or actually two critical reasons. I actually don't have to do research along the way. This sentence, to the contrary, under Virginia law, a statement is not considered to be published until it's seen or heard by a third party. That was said by Nunes versus CNN by the Second Circuit. I see two problems with that. First of all, the Second Circuit is a federal appeals court of the wrong jurisdiction, because Virginia is in the Fourth Circuit, not the Second. So there's that. Second of all, even if this came from the Fourth Circuit, Virginia really does not care, because a federal court saying under Virginia law, blah, 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 is not binding on Virginia. Federal courts sometimes have to guess what states will do. If there's no state law, you know, or sometimes even another state occasionally, because of contract reasons principally. So sometimes another state or the federal government has to sort of guess what a state would do. And they do that by looking at the case law and trying to come up with an informed opinion. They do a good job of it, but, you know, it's not binding on Virginia. Another state can't bind Virginia. The federal government can't bind Virginia when it comes to Virginia's state law. Virginia is the master of Virginia state law. Virginia does not give two shits what the Second Circuit or the Fourth Circuit really have to say about what Virginia's law is. You know who you can ask if you want to know what Virginia's law? How about the Virginia courts? So the Court of Appeals is going to look at this and be like, lol. No. So I don't even know if it's an accurate citation. Even if it is, the Court of Appeals is not going to care. Oh, the Second Circuit, Federal Court of Appeals said that? Oh, that's nice. Why do I care again? Oh, that's right. All right. So then they cite a 1995 case that says uploading the content of the urn is not enough to constitute the completed tort of defamation. Oh, no, I apologize. That's the same case from the Fourth Circuit, so I can continue to ignore that. And then they say, see also Food Lion from 1995. I'm guessing see also doesn't really have a devastating quote from it, or they would have just quoted it directly. Right? That's kind of a tell. Like, okay, so this Virginia case from 1995, if that really were controlling, they would just dump this quote completely from Nunes, and they would just throw in some other language. They'd have a different quote completely here. This quote would be replaced by some other quote, and it would just have a direct citation to Food Lion, but it doesn't. So Food Lion must not have anything that's really, really good. It must somewhere vaguely, obliquely, kind of, possibly a little bit read on it. You know, and then there's their best authority. They have a Second Circuit decision, which isn't the Fourth Circuit and is also federal. So I wouldn't have a lot of hope for that citation, guys. That's the yeah. And then David in chat says the Food Lion isn't on point either, as it's a spoken statement heard by only the two individuals. Okay, fair. Fair enough. That is an element of defamation. David, it is true that a defamation does not occur unless the statement's made to a third party. You can defame a person to their face all you like, and they can't sue you. So, yeah. I wouldn't put a lot of stock in that. Numerous courts interpreting Virginia law have concluded. I love this. Numerous state courts interpreting Virginia law. Law says Virginia. Law. I'm really thrilled, says Virginia, with what the Second Circuit or Maine or California or New Mexico or Illinois or Guam has said about Virginia law. I'm super, super thrilled with all their opinions about Virginia law. Let me tell you what my opinion about Virginia law is, says the Court of Appeals of Virginia. All right, yeah. Oh, and they cite a district court case, Nunes versus Washington Post from the District of Columbia. Oh, okay, the District Court of the District of Columbia, federal court. Yeah, Virginia definitely cares what they have to say about the subject. Oh, the Southern District of New York one time had an opinion about what Virginia law is on the subject. Okay, well, we're really thrilled what the federal Southern District of New York said about Virginia law the one time. We don't care. Here, that state was California Depp's home and the trial court abused discretion. No, that argument sucks. That argument kind of sucks. I think they know it sucks because they didn't spend any time on it. The first time I read it with Legal Bites, I didn't catch some of this. And I thought, oh, okay, maybe there's something more here. And I started going off and started pontificating about Colbert, which incidentally, by the way, is a case dealing on federal law with sufficient minimum contacts as an augment to international shoe. But I thought, maybe we could use some of the logic from Colbert to attack it under state law. So like we can transfer some of the rationale. But now that I read it and I see their citations, I'm like, oh, now I know why they thought it was crap and didn't spend any time on it. Anyways, Virginia was a completely inconvenient forum, was it though? Because the trial court erroneously concluded Depp's claim arose in Virginia, and Heard had therefore not met the prerequisite to dismiss the case based on forum nonconvenience, it did not consider whether there was good cause to dismiss the action. Good cause includes, but is not limited to, avoidance of substantial inconvenience. Well, yeah, that's what forum inconvenience is, right? So the plaintiff normally gets their choice But if the plaintiff technically has a valid choice somewhere, but it really doesn't make any sense because all the facts are somewhere else and all the witnesses are somewhere else and all the paper somewhere else, then, if there's only one valid forum, then so be it, right? You can't forum non-convenient out of your only valid forum. So there has to be an alternative. But if the alternative is, a better choice, sometimes you see that, including by transferring to foreign countries occasionally. Had the court analyzed good cause, it would necessarily have concluded that Virginia was completely inconvenient. Really? None of the conduct relevant to Depp's defamation claims occurred in Virginia. There's the publication in Virginia. The article. Depp is a resident of California. Sure. The incident that led to Heard obtaining the restraining order took place in California, not Virginia. Heard wrote the op-ed in California, then sent to the ACLU in New York. The ACLU provided the op-ed to the Washington Post in Virginia, incidentally, which itself is communication to a third party, incidentally. The Washington Post is itself a third party relative to Amber Heard. So there's that. And the court in New York, I believe, already ruled the ACLU was Heard's agent. And unlike the UK, New York is part of the United States, which means that Virginia constitutionally is required to give the New York decision full faith and credit. So if New York says, okay, well, they're the agent and the issue's already been litigated, Virginia is required to agree because full faith and credit, right? The issue has been disposed of by a competent court of this country in full faith and credit among states. Heard had no contact with a Washington Post employee. Yeah, but ACLU did, and they already ruled the ACLU was your agent, so, To the best of her knowledge, Heard had never set foot in Virginia prior to this lawsuit. I hope you enjoyed your stay. In short, the Washington Post computer server presence in Springfield is the only connection between these claims and Virginia, which means Depp's choice of forum is entitled to little weight. The Washington Post also. In contrast, both parties and most of the fact witnesses were located in California, with none of them located in Virginia. Johnny Depp didn't seem to have any problems with that. Because of this error, Heard suffered substantial prejudice in two ways. First, and most significantly, Heard was unable to subpoena any witnesses for the 6-week trial and was forced to rely almost exclusively on depositions designed to defund herself. Well, Johnny Depp couldn't subpoena people either. Johnny Depp had the exact same problem. It's not like Johnny Depp had some power that you didn't. He also couldn't get subpoenas to compel out-of-state witnesses. The only people that would show up for him were people that wanted to be there. Johnny Depp didn't seem to have any problem with that. I'm guessing that your problem wasn't that you couldn't afford the airfare and hotel to fly some people over. I'm guessing that wasn't the problem. The lack of compulsory process meant first that only live factus witness was able to call on her defense was her own sister. No. Her sister doesn't live in Virginia either. The fact her sister showed up is because she wanted to be there. Also, Depp had people testify via Zoom from the UK. So I'm imagining that, the court would have allowed you to do that too. So, I'm not aware of any problems there. Depp, who has considerably more resources from his decade as a movie star. Let's plead poverty on this. That makes sense, given that your legal team and how much money we know you spent. You spent, what, $8 million or something like that on the legal case? based on the insurance claims that are now going on. I hope you lose and companies come after you for every dime. Johnny Depp may show you mercy, but I doubt the insurance companies will. Depp, who was considerably more resources from his decades as a movie star, was able to call more than 15 live fact witnesses who voluntarily traveled. Voluntarily. He had no advantage that you didn't have. He was in the exact same position that you were. So, same exact problem. Thanks. Appreciate it. Or appeared by WebEx. Why couldn't you have your witnesses appear by WebEx? What was the problem? What was the problem? Why did he have this massive power to get them over to Virginia or appear by WebEx? Why couldn't you do that, Amber? What was stopping you? And also, just as a pure issue of just like pure fact, I'm having a really hard time believing that there's some witness that you could have compelled to be there that would have changed the case for you. If you're going to force a witness to be there who doesn't want to be there for you, this is what we call a hostile witness. I'm imagining they're going to be a little hostile. I'm not seeing what hostile witness you're going to be able to call that's going to totally blow this thing wide open. Since their answer to every question is likely to be screw you. Depp capitalized on this disparity, arguing for the jury. You may have noticed that no one showed up for her in this courtroom other than her sister, other than a witness who traveled to Virginia for her as a paid expert. This is a woman who burns bridges. Her close friends don't show up for her. Why you would put this in your own brief is beyond me. As the appellate court, I just want to write, I agree with Amber Heard's brief. This is a woman who burns bridges. Her close friends don't show up for her. What a self-own. True. I guess it proves occasionally Amber Heard can tell the truth. Second, the lack of compulsory process prevented her from responding as Depp shifted his case. While Depp was able to redirect witnesses, that's part of the process of a trial, and call in new, previously undisclosed witnesses in rebuttal, TMZ guy, but you brought TMZ guy into issue. Heard was reliant on video deposition testimony. That's because none of them want to show up in person, Heard, because you suck. Also, you're just saying this as a conclusion. What witness? This, by the way, you can do this at trial. You can do this at trial, right? So you don't have, so the judge, so for some reason you don't have a witness who shows up. Or a judge says that your witness can't testify. Or they can only testify about some things or not other things, right? Like they can only testify about this, not about this. Or they can't testify about them all, or you can't get them before the court or something, right? So the appellate court can only deal with the record they have. So if a witness doesn't testify, what do? How do you bring it into the appeal, right? How do you bring in what didn't happen into the appeal? Well, there's actually a mechanism for that at trial. It's called a proffer, or it's called an offer of proof is the other phrasing for it. It's called a proffer, an offer of proof, right? So the judge says my witness can't testify. They say they can't testify about these things. The witness can't come because of the lack of compulsion. So what I can do as an attorney, and what I would typically do is I typically do it at the end of a case, right? Or I do it sometime when we're not doing trial, right? I do it sometime when we're doing or not before the jury. So I do it at some convenient time. But what I do is I get up and, say, is there any business before the court? And say, yes, Your Honor, I want to make an offer of proof or a proffer, depending on the language that that particular court uses. They mean basically the same thing. And says, okay, what do you want to say? It's like, okay, my witness, Mr. X, you ruled Mr. X couldn't testify. Mr. X, if he would have been called to testify, would have testified to A, B, C, D, E. Right? Or you said he was an expert. Mr. X did testify, but you said he was an expert as to this, but not to this. If Your Honor had admitted him as an expert as to that other subject, he would have testified as to G, H, I, J, K. Right? So what you just do is you kind of lay it out. You just lay it out. And you know this because you've talked to your witnesses, because you're a good attorney. You're a good attorney and you're making representations to the court. And you're not allowed to lie to the court. So you're like, okay, I want to make an offer of proof or a proffer about the witness you didn't let in, or the piece of testimony you didn't let in, or the question that Your Honor struck, the objection that the objection you sustained. You really should have overruled that objection. If that objection had been overruled, the witness would have testified as to ... And you just say it. You just say it. And then you can get it flushed out with an affidavit if you have to, but usually it's not even necessary. And then you go to the Court of Appeals and say, okay, well, as shown in the trial record, I made my offer of proof. The witness would have said, the witness we would have called would have been so-and-so. And this witness would have said the following things, and that would have really helped my case because of these reasons, right? And isn't the judge bad that they didn't allow those things in? So that's how you do that. That's how you bring it to the Courts of Appeals' attention, is with an offer of proof or a proffer. You put on the record the things that didn't happen. So they say, for example, the lack of compulsory process prevented us from bringing in people. Okay, who? Who? What would they have said? Where's your offer of proof, counselor? Where's your proffer, counselor? As detailed on this page of the record, we would have called Mrs. So-and-so. Mrs. So-and-so is knows Amber because of this reason. Mrs. So-and-so would have testified to the following things. See record, see record, see record. See affidavit. I have an affidavit in my hand, Your Honor, as to what they would say. Now, obviously, it's hearsay, but, I'm putting it on the record to say what they would have said, and so put it on the record, please, Your Honor. Okay, I'll put it on the record so the Court of Appeals can consider it. So they just say, oh, we couldn't compel without saying who. You can't do that. You can't do that at the Court of Appeals. This is the equivalent of saying to the Court of Appeals, we had so many witnesses. Which ones? So many. Who? So many witnesses. And they would have testified to these devastating things. Like what? Devastating, I say. You can't do that. This is precisely a type of disadvantage. Yeah, so this argument sucks because they completely fail to make their offer of proof. Right? They just say, there were witnesses we would call. These witnesses would have been devastating. Who are they? What would they have said? Cricket noises. Cricket noises. You can't do that. Court of Appeals is having none of this bullshit. All right, what's next? The trial court should have dismissed Depp's claims because the challenge statements are non-actionable expressions of opinion. All right, let's give that a shot. Expressions of opinion are constitutionally protected and are not actionable as defamation. All right. Statements that lack a provably false factual connection or are relative in nature and depend largely upon the speaker's viewpoint are expressions of opinion. Wherein a statement is a expression of opinion is a question of law that's reviewed de novo. Fair enough. If it can't, which is equivalent to saying it can't be read the way the jury did. Which, okay. Juries make mistakes sometimes. That's what appeals are for. So, it couldn't be read that way, even though the jury said it did. No reasonable jury could read it that way. All right, let's give that a shot. The three challenge statements, with the exception of the portion of the headline saying, I spoke up against sexual violence, that's a little bit true, are protected opinion. There's no objective basis for asserting the truth or falsity of whether Hurt felt or faced our culture's wrath. Well, she says that she did, and the jury could believe that the jury could conclude she didn't believe that. Whether she is a public figure representing domestic abuse, I mean, that seems like a statement of fact. She's a public figure representing domestic abuse. I mean, that seems true enough. You're appointed ACLU ambassador. That seems like okay. Or whether she saw institutions protect men. These statements are relative in nature. Are they? Public figure representing domestic abuse. I mean, Amber Heard is a public figure. She was appointed ambassador by the ACLU on domestic abuse. That seems like a statement of fact. Okay. These statements are relative in nature and reflect Heard's subjective viewpoints. The trial court violated its essential gatekeeping functions by allowing the jury to consider these non-actual opinion statements. And that's conclusory. That entire argument is just conclusory through and through, guys. It's true. Believe me. Why are they opinions? Because, wow, I'm feeling it all the way over here. I'm feeling it all the way over here. That's pretty conclusory, counselor. Not really buying that one either. What else you got for me? The trial court should have dismissed Depp's claim because the challenge statements are not reasonably capable of conveying a defamatory implication as a matter of law. All right, let's give that a shot. When a defamation claim is based upon allegations that an otherwise non-actual statement conveys actionable implication, the alleged implication must be reasonably drawn from the words used. A plaintiff may plead innuendo to show how the words used are defamatory and how they relate to the plaintiff. But innuendo cannot introduce new matter, nor extend the meaning of words used or make certain what is in fact uncertain. Okay. It is not the province of innuendo to enlarge the meaning of the allegedly slanderous words. It is used to explain matters already expressly alleged. But didn't we kind of do that? We were explaining what the things meant. Like 2 years ago, I became the speaker for domestic abuse, and I saw how men treated Hollywood, who they were talking about, which men. Isn't that to explain what was already said on the page? I'm not sure I get that one. Whether a statement is reasonable, capable of defamatory meaning ascribed to it by innuendo is a question of law. Yeah. It is undisputed the op-ed does not mention Depp's names or parties' prior relationship, describe the 2016 restraining order, although it said 2 years ago, or discuss Heard's statements or evidence in that proceeding, although it said 2 years ago. Rather, op-ed advocates for changes to laws and rules and social norms regarding domestic violence and sexual assault so that women who can come forward about violence receive more support. Again, where men are in any of this is apparently a mystery. Notwithstanding the absence of any express reference to the allegations underlying the proceedings, that would be why defamation by implication, Depp's position is the op-ed implies he abused Heard because reasonable readers would understand the words, 2 years ago I became a public figure representing domestic abuse, to refer to that proceeding. I mean, yeah, that's what it was. What happened 2 years ago relative to domestic abuse? You know, it does sort of invoke that concept of mine. Depp contends, in other words, that Heard revived her allegations simply by describing the op-ed, the public backlash she faced after obtaining the restraining order. Did she? Unless the advocate means the backlash she's receiving now, which is technically after receiving the restraining order, which is one of those wonderful things that lawyers get to do. Lawyers can only speak the truth, but you know they can mislead with the truth, which at least according to Immanuel Kant, there is a difference between those two things. And Immanuel Kant is one of my favorite philosophers. So there is a difference between a misleading truth and a lie, according to Kant, and perhaps according to these advocates as well, right? There is a public backlash she faced after obtaining the restraining order. How much after is left to the reader's imagination, I suppose. Depp's theory of liability extends the meaning's words used beyond recognition. The reasoning in Fairfax which is also a federal case decided by the Fourth Circuit, which is still not Virginia State, is illustrative. There, the court considered where the host of a television news program defamed the lieutenant governor, Fairfax, while interviewing two women who had accused Fairfax of sexual assault. The court concluded that Fairfax had failed to plead defamation by implication. Because the host had not stated that Fairfax did not in fact commit the alleged sexual assault, and then the challenge commentary did not ascribe to any particular view of the underlying events, but rather focused on how persons who believe they're victims of abuse are effective. Well, that might be true in the facts of that particular case, but Similarly, in the op-ed, Heard did not recount the events underlying the domestic violence proceeding. Rather, she discussed how women who allege domestic violence are treated by society, and she advocated for changes relevant to laws and social norms, even apparently if those women are lying liars who lie. To accept, as the trial court did, Depp's assertion that a reasonable reader could understand the op-ed to imply that he abused her merely by describing the public relations reaction to her allegations would create a rule preventing any abused person from addressing the societal implications of speaking out about abuse. If that were the law, then it would be actual defamation to say, 4 years ago, Christian Blasey Ford became a public figure representing sexual assault. That is plainly not the law. Well, I think there might be a difference about talking in the third person and saying, 4 years ago, I became a public figure representing domestic sexual assault. And also, I'm not sure Christian Blasey Ford is necessarily your best example in this sentence. Because, I know she has political cachet and all, but if you're looking for women who are victims and who the law should extend more to, I'm not sure Christian Blasey Ford is necessarily your best example. I think you could look for better. So that example seems like we're pushing for political points rather than a win. I think there's got to be a better name to put into that sentence. The trial court's ruling also contravenes the doctrine of judicial privilege. The statements Heard made in the course of obtaining the restraining order were absolutely privileged. In the proceedings, yes. Permitting a claim for defamation by implication premised on a person's published statements about her experience in the aftermath of a judicial proceeding would substantially undercut the public policy served by judicial privilege. First of all, this argument completely undercuts the claim Amber Heard has against Johnny Depp, because it would have to be necessarily true the other way around, right? But more to the point, there was a lot more time involved, which is also another reason to find in favor of Johnny Depp. Waldman's statements were made, I believe, as the UK proceedings were ongoing. Her statements were made 2 years after the fact, encountering all that. So there's a temporal proximity element here that works against Heard. So you could split this on temporal proximity. You could make the idea that statements made during the scope of the case and in some sort of proximate time frame to the case might be covered by judicial privilege, but this is too late. So you could split it that way if you were so inclined. Which, if you do split it that way, would still allow you to rule for Johnny Depp with regards to Waldman, but rule against Amber Heard, because the temporal proximity elements disfavor Amber Heard. Freddie Lee says, please get a thanks button, the only way I donate. Thanks buttons, I do have thanks button. The thanks button, I believe, is only available after a stream ends or a video is posted. So I don't believe the thanks button is available while a stream is ongoing. You can super chat while a stream is ongoing, or you can donate via PayPal or Stripe or Streamlabs. But the thanks button, I do not believe works while streams are ongoing. But thank you very much for your your thought and your willingness to donate. It helps. You can give a thanks on a prior video if you like. One that's already been posted, the thanks button should be available there. In overruling Heard's demur on the issue, the trial court relied primarily on Pendleton versus Newsom, a defamation action brought by the mother of a student who died at school from a peanut allergy. The proximity element here is, of what it's relating to is more notable, but then again, Heard is a more public figure, so there's a counter there. But in Newsom, the mother alleged that school officials had made statements to the public and press in response to an incident implying she was to blame for her child's death. They sure did. For example, an official said the school trained professionals can only be effective if a parent provides information, doctor-prescribed health plans, and medicines necessary to carry out those plans. Unfortunately, that does not always occur. But it did occur in this case, and Pendleton happened in the immediate aftermath of the death, so it was very clear what they were talking about. Here is 2 years ago, which is more temporarily distant, but also it's a public figure and more notable, so there's that as counter. The Supreme Court held these statements were reasonably capable of conveying defamatory implication, the mother alleged. Unlike here, the statements in issue in Pendleton were a direct response to questions about a child's death and assertion of a parent's failure to communicate key information about allergy impedes treatment of allergic reactions. Thus, the words used by defendant readily implied a causal relationship between the child's death and mother's actions or inactions. In stark contrast, I don't know that it's stark, but okay. In stark contrast, the op-ed, you want to be careful with using words that are overly strong. Like, this probably would be better just by saying stark contrast rather than in stark. This would be better by saying in contrast rather than stark contrast. Stark is too stark a statement, right? It's not really stark, and the gap is more noticeable. So sometimes you have to be careful with these kinds of word choices because I think they can kind of bite you in the butt. You have to know like where to be as an advocate, and I think you're pushing it too much. The op-ed does not refer to Johnny Depp or say anything about Heard's abuse actions or the judicial proceeding in which he obtained the restraining order. Trial court improperly allowed Depp to use innuendo to enlarge the meaning of the alleged statement. Did they? Did they, though? I'm not so sure about that at all. Just a kind reminder from the sponsor of this channel, me. For the 684 of you who are currently watching, please become an uncivilian today. You can do that by hitting the join button, or you can hit the link that Streamlabs just told you about and is currently displayed on stream. For your 99 cents a month, it is literally the least YouTube will let me charge you. You can help support my channel and help it grow, and help me to do things that are fun and interesting for the channel, and maybe even travel for the channel and go visit places that will be relevant to stories and things like that. Get better equipment, maybe get a separate room for a studio, stuff like that, so we can help to improve the content. So if you would be so kind as to follow the link that the Streamlabs bot has told you about, or hit the join button, or hit the link in the video description below, it would be really, really appreciated. Please consider supporting the channel by your 99-cent contribution. What you get for your 99 cents is you get cool little scales of justice by your name, and you also get access to some cool emojis, plus that sense that you're helping to support an Uncivil Law. So thank you very much, Streamlabs. And I appreciate Shelly for the super chats, and for everyone donating and becoming members today. It is super awesome. In post-trial motions, Heard made, and trial court erroneously rejected, a related point. The trial court should have held a plaintiff cannot recover for defamation by implication, where the alleged implication is based on statements that are true on their face and involve a public figure on a matter of public concern. So this is apparently the law in some jurisdictions. Some jurisdictions say we do allow defamation by implication, but not for public figures. So apparently some states split it that way. We do allow defamation by implication, but not with respect to public figures. Virginia has never spoken on this issue explicitly, They've said defamation by implication. They've never explicitly said one way or another when it comes to public figures, but I think that they're probably likely to allow it. I don't think they're likely to go along with what seems to be a minority of states. So apparently, Louisiana, Minnesota, New Mexico, Colorado, and New Jersey do not recognize defamation by implication with respect to public figures, at least in some respects. But, you know, thank you, Tony, for your super chat. Maybe I'll do that when I get back to my studio, when I get back home. So maybe on Monday I can pick that up and see what interest is. But yeah, maybe I'll take a look at that. Thank you. This court should adopt the same rule here too, to further public interest on speech on matters of public concern, including a speech about how segments of the public react after someone makes allegations of abuse, and hold that failed to prove defamation by implication because he did not prove the statements are false on their face, which would somewhat defeat the concept of defamation by implication. But yeah, so they want to change the law in Virginia. I seriously doubt the Virginia Appellate Court is going to take them up on their opportunity. So their only hope is in the Virginia Supreme Court, and I'm not sure they want a piece of this either. Ensuring that defamation suits proceed only upon statements which actually may defame plaintiff rather than those on which merely inflame a jury to award damages is essentially a gatekeeping function of the court. The trial court failed to fulfill that role, and the court should reverse and dismiss the claim because Depp cannot make out the claim for defamation of implication as a matter of law. No. Can't defame the dead. That's also generally true as a matter of law. The trial court should have dismissed Depp's claims because the doctrine of issue preclusion prevents relitigation of the UK's ruling that Heard abuse accusations are substantially true. All right, so before I read this, I'll explain a little bit about claim preclusion and issue preclusion so that you understand what we're talking about. All right. Claim preclusion refers to the concept of literally the exact same claim. Issue preclusion relates to claims that are in common. So I'll give you an example. Let's suppose I want to sue you. Let's suppose, based on whatever the issue is, you know, you've done some things that are part of this package, and I want to sue you. And let's suppose I have 10 possible causes of action. Okay, maybe I have defamation, maybe I have false light, maybe I have interference with trade, or whatever, right? So I have 10 possible causes of action, right? Now, as it happens, I have more than one place I could sue you, more than one state even, right? I have more than one state I could sue you in for these 10 causes of action. So as it happens, I can sue you in Florida, or I can sue you in Texas, okay? So I can sue you in one of these two places. All right. So I've got to make a choice, Florida versus Texas, and I can file in one of those. So let's suppose I choose Texas because, you know, I live in Texas, so hey, more convenient for me, right? So let's say I choose Texas, and let's say I sue you for only 3 of the 10 things, okay? And let's say you win on those 3 things. All right, so claim preclusion would be if I said, you know what, upon reconsideration, the law in Florida is actually better for me. I really should have sued you in Florida in the first place. And the law's better for me, and so I should give that another bite. So I'm going to take those 3 causes of action that I lost on, and I'm going to refile them in Florida, right? The exact same 3 causes of action. Well, claim preclusion, right? I've already lost on those exact same claims. So I can't do that. That's claim preclusion. Issue preclusion would be, okay, I had 7 other causes of action I could have brought. I didn't really think that they were very good, But, since, what the hell? Maybe I can convince some jury to think about it anyway. So I'm going to file those 7 causes of actions I didn't file in Texas. I'm going to take those over to Florida, and I'm going to file those. So you yell claim preclusion. I say, well, they're not the same claims. So what do? You yell issue preclusion, right? It's all common to the same issue. It's common to a common nucleus of facts, right? You had the choice. You only brought those 3 claims, not these 7 claims. You could have. You can't bring them now. Issue preclusion, right? So those claims are gone. Res judicata. So that's the difference between claim preclusion and issue preclusion. So now you want to do that. Now, so with Amber Heard, she has 2 complicating factors that make this, well, she has 3 complicating factors as it happens. First complicating factor of claim preclusion, issue preclusion. First complicating factor is it is not necessarily a common nucleus of facts. The one in Virginia concerns what happened in the Washington Post. The one in the UK concerns what happened in the Sun. These are 2 different newspapers with 2 different things that are understood at 2 different contexts. So we have a difference as to a common nucleus of facts. Second complication, Amber Heard is not a party in the UK case. So we have to do this as a third-party claim. So third-party claim preclusion, third-party issue preclusion. I wasn't sued before, but even I as a third party should benefit from that anyway. Third complication for Amber Heard, it happened in the UK, not another state. The United States, every state is required to give full faith and credit to every other state. UK is not a state of the United States. England is not a state of the United States, nor is Virginia part of England or the United Kingdom for quite some time. So, third complication is we're trying to do the issue preclusion, claim preclusion thing with respect to a foreign court. So I've explained to you what issue preclusion versus claim preclusion is, and we've got 3 problems. We've got disparate on the nucleus of facts. We've got Amber Heard wasn't a party to one of them, so we're trying to do this as a third-party beneficiary, essentially, and we're trying to use this in the UK and apply it to America. So that's a lot of stuff to overcome. That's a lot of stuff to overcome at the same time. Some of those things can be overcome in some situations, but to overcome all of them at the same time is asking a lot. So I don't have high hopes for that as a result. So issue preclusion bars successive litigation on an issue of fact or law actually litigated and resolved in a court of valid determination essential to a prior judgment if the issue reoccurs in the context of a different claim. Right. The fact or law, but do we have either of those? Well, the law is the UK. The fact is the newspaper of the Sun. So, it's not looking great. The public policy underlying the doctrine is to relieve parties of the cost and vexation of multiple lawsuits, conserve judicial resources, and by preventing inconsistent decisions, encourage reliance on adjudication. Put differently, one adverse litigative adventure on one issue is enough for any one litigant. To establish issue preclusion, a party must show the relevant factual issue was actually litigated in the prior proceeding, which it wasn't, because the issue was the newspaper article, and whether it was defamatory. That was essential to the prior judgment, and the prior proceeding resulted in a valid finance judgment against the party with whom the doctrine is sought to be applied. That's okay. So, all right. In certain circumstances, the party asserting issue preclusion must also show mutuality, that is privity. So we're trying to do this as a third party, right? So the same parties in the UK versus the same parties in the US is one less complication. Here, the parties are distinct. The Virginia Supreme Court has recognized that mutuality doctrine should not be mechanically applied when it's compellingly clear from the prior record, prior record, that the party in subsequent civil action against whom collateral estoppel is asserted has fully and fairly litigated. Let's see what happens if I do this. Thank you for letting me know. Yeah, I wasn't sure if that was going to work or not. Okay. I wasn't sure if that was going to work or not. So thank you for letting me know. I was doing am I still, oh, you didn't miss anything. I was doing a little song and dance over whether or not I was still muted or not. So you didn't miss anything. All right, anyways. The Virginia Supreme Court has recognized that mutuality doctrine should not be mechanistically applied when it's compellingly clear from the prior record the party in the subsequent civil action against whom collateral estoppel is fully and fairly litigated and lost to an issue of facts which was essential. The traditional rationale for mutuality does not apply where issue preclusion is assertive defensively. That is, where the defendant, which in this case would be Amber Heard, a stranger prior to the proceeding, attempts to preclude the plaintiff, which would be Johnny Depp, a party in the former proceeding, from relitigating an issue the plaintiff lost in an earlier case. It seems like that cuts directly against you, Amber Heard, so I'm not quite sure what you're trying to do there. Seems like that's 100% against you. Where a plaintiff has already had his day in court, with the opportunity to produce witnesses, to examine and cross-examine the witnesses for the other side, and to appeal the judgment, there is no sound reason to allow him a second bite at the apple. Whether an issue is precluded by prior judgment is a question of law for the appellate court to decide de novo. The UK judgment meets all the requirements for non-defensive issue preclusion against Depp, yet the trial court erroneously required mutuality. Well, that was one of the three problems, so you know. Mike, I'm not sure if this is necessarily a family channel with learning, but I'm glad we're all learning anyway. There may be the occasional cursey word, or more than occasional, depending on my mood at the time. There's no dispute that the truth of Heard's allegations was actually litigated and essential in the prior judgment in the UK proceeding. The Sun published an article calling Depp a wife beater, and Depp sued the Sun, alleging it defamed him because the abuse allegations were false. In rejecting Depp's claim, the UK court found, based on much of the testimony, based on the same evidence, that Depp had engaged in at least 12 acts of domestic violence, causing her to fear for her life. Yeah, we're not quite sure how the UK saw any of that, but okay. The UK court therefore concluded the defendants had proved the Sun's description of a wife beater was substantially true. Yeah, I don't know that this is an example where we're feeling particularly deferential to the UK today. No. There's no question Depp had a full and fair opportunity to litigate this issue. There's some question. Depp chose to file a libel suit in the UK predicated on the same abuse allegations that he contends were revived by Heard's op-ed. Indeed, Depp's UK counsel asserted prior to trial that his clients could only be vindicated by clear and reasoned judgment from the UK court. Well, apparently he found another opportunity. Well, I guess that was a true statement at the time the UK suit happened, because the Washington Post article hadn't happened yet. So at the time when he said it, yeah, it was true. I can only be vindicated by a UK judgment. But now I can be vindicated by an American judgment because new things have happened. The parties to the UK proceeding have engaged in extensive discovery and motions practice, and Depp also had access to the discovery conducted in the case for 16 months prior to the UK. The UK trial included 4 days of testimony by Depp and Heard, as well as 24 other witnesses. Yeah, the US decided, instead of the 4 days, how about 6 weeks? So I think our proceedings were a little bit more thorough. Yeah, secret mixed squirrel, which the law can be an uncivil place, but we try to keep it mostly civil around here. The law can be a little uncivil, but or it relates to the uncivil, people being uncivil. That's what the law is all about, right? The law is all about people being uncivil. But we try to keep it a little bit more happy here. Okay, and under UK law, Depp faced a much lighter burden of proof on his claims than he did in Depp. In the UK, defendant bore the burden of proving truth rather than Depp having to prove the burden. Yeah, he shouldn't have lost in the UK, but he did, which says a lot about the UK. It's harder to win in the US, but it is harder to win in the US, but upon a poll evaluation. Thank you, Gail, for becoming a member, by the way. Thank you for hitting that beautiful, beautiful join button. I do appreciate everyone who becomes a member of the channel. And thank you, Kim, for hitting that beautiful, beautiful join button. I really, really appreciate everyone who becomes a member of the channel. It makes the channel possible. It's all I want for Christmas. All I want for your Christmas is your 99 cents a month. So it's all you have to get this Uncivil Law. And I do appreciate each and every one of you who helps. Secret McSquirrel says they're trying to find a channel where they can learn law through the power of interpretive dance. I'll see what I can do in the future, Secret McSquirrel. In short, Depp had his day in court and should have been precluded from relitigating the exact same factual issue. That was decided against him. Accordingly, the court should reverse. Now, I don't see this as I don't really see this working either. I don't see the court, if this would be a reason, all these reasons would be reasons for the trial court to have said no. Right? So if Judge Ascarardi had made the other decision, said no, these rationales would be a way to defend it. Right? So that's a lot to overcome, but the judge is the judge. So, if the judge looks at all of it and be like, I think it's right. But at this point, if you're the Court of Appeals, we've already had the trial. We've already had the 7 weeks of testimony, right? And so it's well, the trial court probably would have been within its discretion. That's one of the things about abuse of discretion. It allows for a potentially wide range. The court probably would have been within its discretion to say, we're not going to do this lawsuit because of these reasons. But the trial court saying, there's just too much stuff here. I don't think so. And also, this is a new publication and all the rest of it. So the trial having already happened, any sort of issues from comedy and sort of in judicial efficiency, they don't make any sense anymore because the trial already happened. So I don't really see this as a valid appellate issue at this point. That seems odd. The trial court erred in denying Heard's motion to set aside the jury's verdict based on Depp's failure to prove actual malice. I don't think so. They put Amber Heard on the stand and asked questions. The jury is allowed to believe she's a liar. Both under the First Amendment as a matter of state law, Depp as a public figure challenging statements to the public on a matter of public concern was required to prove by clear and convincing evidence that Heard made each of the statements with actual malice. Actual malice is a term of art that means the defendant either knew the statement was false, and that's where we get her, because she would know whether or not she was abused, as an ordinary common person would understand that term. In defamation by implication cases, establishing actual malice requires making a secondary showing. Not only was Depp required to show knowledge of or recklessness in regards to the falsity of the statement, he is also required to demonstrate that your defendant intended to communicate the defamatory meaning or knew the defamatory meaning and was reckless with regard to it. Well, she did testify that the article was about Johnny. And she probably can know what sexual violence means and abuse means to an ordinary person. So I don't think she opened her mouth, and I think you're there. Without this requirement, a defendant could be held liable for what was not intended to be said would eviscerate the First Amendment protection recognized by the Supreme Court. If they ask certiorari for the United States Supreme Court, which I'm sure they are, I look forward to reading that brief. I look forward to reading the eventual writ for certiorari. That will be fun. With all those amici, I'm sure that will be really entertaining. If they file, dude, if this winds up before the U.S. Supreme Court someday, I might write a brief. Never written one before the U.S. Supreme Court. Now's a good time as any, right? When the trial court is sufficient to support a finding of actual malice is a question of law, and the court must make an independent review of the record. Sure. We'll have to crowdfund it, but yeah. Significantly, in deciding the issue, this court must evaluate the record in light of Depp's burden to prove two prongs of actual malice by clear and convincing evidence. Thank you, Mike. That's very nice. I make the law interesting. Thank you. That's very kind of you. Thank you very much. I try very hard. I appreciate that. You warm my heart, Mike. Thank you. A person cannot knowingly or recklessly tell a falsehood if she did not intend to and was not aware of the words she used would be understood to communicate such a falsehood. But what she understood or what she knew is a question of fact for the jury. The evidence at trial fell short of establishing by clear and convincing evidence that Heard had communicative intent to accuse Depp of domestic violence. The undisputed evidence, undisputed, there's that word again, shows the ACL proposed that Amber Heard author an op-ed on the ways in which survivors of gender-based violence have been made less safe under the former president's administration. The ACLU then prepared an initial draft of the op-ed. Heard engaged her attorneys and, based on their advice, made significant efforts to remove all references to Depp and their marriage from the draft. But she said the op-ed was intended to be about Depp. So we have that testimony. As Heard explained, the purpose of the op-ed was not to discuss Depp or the particular allegations she's raised, but rather to discuss what happened to her in the public arena after she spoke out. Yeah, that might have been her testimony, but the jury was privileged to disregard it. That's what juries do. The jury can think you're a liar. When you say, this is what I thought, this is what I knew, this is what I felt, this is my idea, this is my intent, the jury can ask themselves the question, are those things true? Did she think that? Did she feel that? Did she have that intent? That's what juries do, my friend. In some, Depp presented no evidence, much less clear and convincing evidence that Heard either intended to communicate through the op-ed that Depp abused her or knew the defamatory meaning and was reckless in regards to it. Indeed, the opposite's true. I don't, and that's a little conclusory, so I'm not sure about any of that. Depp failed to prove by clear and convincing evidence that Heard knew the alleged implication that she had abused her was false or subjectively entertained serious doubts about its truth. Even if the court concludes the record contains clear and convincing evidence that Heard knew at the time of publication, the op-ed communicated to readers the implication that she was asserting that Depp had abused her, which she said it was about Depp. So, the record contains no evidence she knew or thought it likely such a statement was false. Depp failed to carry his burden on actual malice for the separate reason. In this regard, it bears emphasis there's a significant difference between proof of actual malice and mere proof of falsity. Depp cannot prevail merely by proving the abuse did not occur. Well, typically that's true, but not in this case, because she would know that the abuse didn't occur because she would have been there when the abuse was not occurring. So typically, mere falsity is not enough. But in this situation, it is because Heard would have been there for the not beatings. Rather than establish actual malice by clear and convincing, he's required to offer affirmative evidence that Heard did not believe he had abused her or entertained serious doubts about whether he'd done so. Well, we saw the pictures of the abuse. We saw the pictures of the abuse. And then we heard her describe the abuse. And I couldn't help noticing some major disparities between it. So I Yeah, and if she had gone and basically offered mental health as a defense, then maybe, right? If she had gone there and said, I am so whacked out in my head that I thought this was abuse, then maybe, because that would go to her subjective state of mind. But she didn't plead mental deficiency. She said, I'm sane and reasonable. All right, so if she's sane and reasonable, she says, I'm sane and reasonable and thoughtful, then she's the reasonable man. That's what she is, right? Either I'm cray-cray, in which case I'm not the reasonable man, or I'm sane, in which case I am the reasonable man. Great. You know who also is the reasonable man? The jury. So the jury can say, aha, you claim to be a reasonable man. Well, that's interesting, my good sir, because we, the jury, collectively are the reasonable man. That's what we are. We embody the reasonable man. That is literally our role in the system. We are literally the embodiment of the reasonable man. We are him. We are him manifest as a panel of people. And you say that you're a reasonable man. Well, here's what a reasonable man would think. And you say that you're a reasonable man. And that's not what a reasonable man would think. So you must have been lying. So it all flows. It all flows perfectly logically. It all flows perfectly logical, right? A reasonable man would look at these pictures and not say, okay, I was beaten by being put down on a pool table and bashed with rings on my hand and then choked up against the wall and I had a bottle put inside of me in this epic throwdown beating. And then the next day went on the Jimmy Dorn show and a little magic makeup and Amica cream made it all better. Those are not opinions of the reasonable man. So the jury can say to themselves, that's not the opinion of a reasonable man. And since you say that you're the reasonable man, and that's not the opinion a reasonable man can have, because you said it's your opinion, and it's not an opinion a reasonable man can have, therefore you must be lying. That must be a lie. That's what we call a logical inference. Was it not Jimmy Dore? Who was it? It was one of them. They're all the same. Yeah. Which one was it? Okay. Insert actual name here. It was not Jimmy Fallon. I know that. Don't try to lie to me. Depp alleged that the op-ed Corden, there you go. Corden, James Corden, there you go. Depp alleged that the op-ed falsely implied that Heard was a victim of domestic abuse by him. Because actual malice is a subjective standard, whether Heard believed Depp abused her must be judged by her own state of mind. Yes, that's true. That's one of the reasons. That's one of the things the jury can do. They can literally judge her based on her own state of mind. What was your state of mind? We get to judge that. We get to determine that. We get to look inside your skull. It's a scary place, but we get to do it. Heard testified unequivocally she believed Depp abused her physically. The jury can say to themselves, you're full of shit. Depp, an expert witness, conceded that abuse takes many forms, including verbal, emotional, and psychological. As to what abuse means, or sexual violence, it was sexual violence and domestic abuse, wasn't it? As to what those mean, those are up for the jury too. So abuse might mean that in some context. What it meant in this particular context is up for a jury to determine. And trial record contains considerable undisputable evidence supporting the proposition that Heard, at time of publication, believed Depp had abused her. For example, Depp demanded that Heard cut him with a knife and threatened to cut himself in his presence when she refused to comply. That testimony is coming from Heard, right? So Depp engaged in violent behavior in Heard's vicinity on multiple occasions, including kicking cabinets and doors, smashing glasses, punching a light fixture, and toppling racks of clothing and throwing a rack of... I don't think that's what the jury thought that sexual violence meant. I don't think that's what they thought that meant. I don't think that's what they thought domestic abuse meant in the context of the article. What would the reasonable man reading the article think sexual violence meant? What would the reasonable man reading domestic abuse think it means? Probably not this. Depp exhibited jealousy and controlling behavior towards Heard, such as accusing her of infidelity and promiscuity, including in messages written around the house with his own blood, and forbidding her from acting in movies or having meetings. Depp admitted to headbutting, though he claims it was unintentional. You show me a reasonable man who hears the term domestic abuse and thinks maybe they headbutted once, and we'll talk. Show me the reasonable man who thinks domestic abuse includes one time a headbutting by accident, and I'll show you a fool. Depp told Heard on one occasion, I left last night, honestly, I swear to you, because I just couldn't take the idea of more physicality, more abuse on each other. Wow. Importantly, even the jury could have properly concluded these undisputed facts did not constitute abuse, and a reasonable jury could not have done so. Yes, they absolutely could have. They really, really could have. They really, in my humble opinion, really could have thought this did not mean domestic abuse. They really could have thought that. They could have thought that this does not rise to that level. They could totally think that. In terms of what the article was conveying. In terms of what the article was conveying when it said domestic abuse and sexual violence, yes, a jury really could think this does not rise to that level. We headbutted once, a jury could think, nah, that's not it. Depp presented no evidence that undercut Heard's testimony she believed the conduct of abuse. Yeah, we did. We showed lots of testimony that shows their thinking process is wackadoo. Consequently, Depp failed to meet his burden of showing. Yeah, right. The trial court erred in failing to grant a new trial for multiple reasons. Okay. For each of several independent reasons, the court should reverse the judgment in favor of Depp and enter a judgment in favor of Heard or dismiss the claims without prejudice. If, however, the court disagrees with all foregoing, then at a minimum should reverse and remand for a new trial. Well, that would be good for me in the grift, I suppose. It'd be good for me in channel growth. So, but, first and foremost, I want the law to be done. So, I mean, so far, I'm not feeling a lot over here on it. Trying to give this its due as much as I can. So it'd probably be good for me personally if they reversed, but I don't know. We could do this all over again. That'd be hilarious. All right, let's give this a try. The trial court made numerous evidentiary errors that severely prejudiced Heard. Okay. On an abusive discretion standard. This court reviews the trial court's admission of evidence for abusive discretion. The trial court's numerous erroneous rulings prevented the jury from receiving evidence highly probative of truth of implication Depp alleged, the op-ed conveyed, and Hamburg's lack of actual malice, while also permitting the jury to receive irrelevant and unduly prejudicial evidence used by Depp to attack Heard on purely collateral matters. Cute. Purely collateral. That's cute. Again, I think they make a mistake here with these adjectives. Like collateral matters, but purely collaborative matters. Like it's too clever. Like, drop some of these adjectives. I think it's like you're like, it's a slightly more subtle approach might be the way to go, rather than being like it's black and white and we're clearly on the side of righteousness. A slightly more nuanced approach might be the way to go here. I think this has a bit of tone problems. Clearly mandates reversal. Again, it's just like, I don't know. I'm not sure that I approve of the strategy on that one. Long before Heard sought a restraining order in 2016, Heard made numerous contemporaneous statements to third parties about Depp's abusive conduct. Instead of permitting the jury to consider this critical evidence, the court excluded it based on an erroneous application of Virginia hearsay law. Statements about Depp's abuse made years prior to potential litigation was essential to the jury's consideration of the facts and Heard's credibility, especially given that Depp made Heard's credibility the linchpin of his case. Okay. From 2011 to 2016, Heard sought treatment from several medical professionals as a result of her volatile and violent relationship with Depp. A number of these professionals document Heard's contemporaneous statements, so they're statements from Heard, which makes them hearsay, about Depp in the records. The trial court, however, excluded this evidence as hearsay, which Depp then used as both a shield and sword. Not only did Depp convince the court to preclude Heard from presenting relevant admissible evidence. Why is it admissible? You haven't gone that far. You're just assuming it is. Please show me why it's admissible. Why is it not hearsay? But then Depp weaponized that exclusion, arguing to the jury that such evidence did not exist. Ms. Heard told you that she has mounds of evidence of abuse, but there are no medical records reflecting she sustained any injuries from the abuse she claims, which is a true statement, by the way. Any injuries. This is why, as a lawyer, it's very important on your word choice, right? If they had said some other word, like any harm, if they said any harm versus any injury, right? So injury, implies physicality, and I believe it was even more implied in the context. So smart on the lawyers, because like they can't say that if the records don't exist, right? But they can say there are no records of physical abuse, because there aren't, right? So they can't lie. So there's no medical records reflecting she sustained any injuries. That's a true statement. The records do not exist in reality. That statement is unequivocally false. It is really not. The trial court wrongly excluded those very mounds of medical records. There are no records of injuries, that she sustained injuries. Virginia hearsay rule precludes introduction of an out-of-court statement offered to prove the truth of the matter asserted, only if the statement does not fall within one of several recognized exceptions. One exception is for statements made for the purpose of medical diagnosis or treatment. And then they cite the Connecticut court for that proposition, or Virginia Appellate Court, Lexis, what is this? VAP. I'm not sure what that is. Court of Appeals. Oh, I'm sorry. That's Court of Appeals, not Connecticut. So yeah, it doesn't for the purpose of medical diagnosis or treatment, but these particular allegations were, would be like there's no verifiability to them. Trial court should have admitted Heard's statement to include records. I don't know. They're admissible under business records? No, they're not. No, they're not. Nice try, though. Separately, the trial court should have admitted Heard, and also the statements made for the purpose of diagnosis, I think only relates to statements from like a nurse or healthcare professional, not the patient. But I'd have to double check. Teresa says, can they accept the appeal just so they can rip the lawyers a new one? Yeah, the Court of Appeals has no choice but to accept the appeal. She has appeal as a matter of right. Unlike in the UK, for example, where they have to ask for appeal. She doesn't have to ask for appeal. She has the right to appeal as a matter of right. The Court of Appeals, sadly, is required to consider this case. Now, they can consider the case in a multitude of ways. They can consider it on the papers. They can consider it by issuing a one-paragraph statement that tells them to go to hell. But yeah, the Court of Appeals has no choice but to accept the appeal. Then what they do with the appeal, well, that's a whole separate question. But yeah, the appeal has been accepted. They had no choice in the first place, and they may have some words for the attorneys. That's possible. Because Depp's burden of proof of actual malice, Heard's subjective state of mind regarding whether abuse occurred was a primary issue. Thus, evidence she subjectively believed she was a victim was critical. Didn't they reject JD's right to appeal? No. JD appealed too. I don't know what you're talking about. JD appealed his things. We read his brief. In the UK trial? Oh, in the UK trial, sure. But that's an American rule, not a UK rule. In America, you have an appeal as a matter of right. Not so much in the UK. But in America, this court had no choice. In the UK, apparently they do. So, okay. The UK and Virginia are, in fact, different places. Here, the trial court improperly prevented the jury from considering several separate instances in which Heard reported Depp's abuse to a medical professional. From 2011 to 2014, Heard was treated by a clinical psychologist. Dr. Depp's contemporaneous medical records show Heard repeatedly reported Depp's abuse. For example, in 2012, Heard reported that Depp was in a rage, accusing her of cheating and threw a glass by her head. Well, we heard testimony regarding that, incidentally, during the trial. In September 2012, Heard reported Depp was violent and ripped her nightgown, threw her on the bed, tried to have relations but couldn't get hard, made more angry. Heard reported sometimes Johnny became verbally and abusive after spending time with his father. Thank you, by the way, for all the gift memberships in chat. That's very, very kind of you for the people giving gift memberships. Thank you, Steve A, very, very much for all those beautiful, beautiful gift memberships. It is super, super appreciated. Let's see. And for some reason, there it is. I was wondering, why is the text not showing up? There it is. Finally, getting around to it, Streamlabs. Anyways. From 2014 to 2016, Heard sought treatment from nurse Erin Falta for injuries caused by Depp. Falta's note that on December 16, 2015, Heard reported that Depp headbutted her. We heard testimony about that. And in 2016, Heard reported that Depp slapped her in the face. I think we heard about that too in the trial. So we already heard about these things from her herself in the trial. In 2015 and 2016, Heard and Depp saw Laura Anderson, a clinical psychologist who was treating them. During her therapy sessions, Heard reported that Depp slapped her, hit her in the head, pulled her hair, and kicked her in the leg, causing bruises. We always saw pictures of some of the bruises. Yeah, Steve, you're exactly right. I do get the same amount from gifted memberships as super chats, and that being the case, I do prefer gifted memberships to super chats. They are appreciated, not for the least of reasons that, maybe some of them will choose to pay on their own. So it gives me the same with the possibility that it will encourage them to potentially, sign up on their own initiative. So memberships are better because they have a probability, they have some probability of having the memberships extended. Because I was already signed up, maybe I'll just keep it going. So, hey, why not? It's good for the grift. Make sure all those uncivilians show our new members some fish bees, because you get access to some wonderful emojis, including the fish bees. Show them some fish bees in chat. Show some fish bees for some member love. In 2015 and 2016, Amber Banks, a clinical psychologist, treated Heard and Depp. In a joint session, Heard discussed Depp's violence, which he did not contradict. Silence is not acceptance, by the way, so that doesn't work. These statements, which were made long before Heard would have any motive to fabricate, well, except she's a lying liar and needs the support because she's a narcissist, each should have been admitted as statements made for the purpose of obtaining medical treatment for both emotional distress and physical injuries and showing state of mind. Moreover, each of these statements about Depp's abuse, whether made to medical professionals, family, or friends, should have also been admitted for independent reasons than their prior consistent statements. Rule 2801D2 says, a prior statement that's consistent with the hearing testimony of a witness is admissible for the purpose of rehabilitating witness credibility. Ordinarily, proof of statements made by a witness out of court cannot be received to corroborate this testimony, but such statements may be admitted where the credibility of the witness has been assailed on the ground, the story is a recent fabrication or some motive for testifying falsely. Okay, they have something a court of appeals could actually get their heads behind. So, this argument could actually work. So I'd be interested to see what the other members of the Law Tube who have been covering this say about this line of argument. Because I read this line of argument, I'm like, there are some potentially non-hearsay reasons that this could be admitted. State of mind, not for the truth of it, but to show state of mind. Not for the truth of it, but to show prior consistent to rehabilitate. Maybe. Once Depp attacked Heard's credibility and accused her of fabricating, the trial court should permit her to introduce these prior consistent statements. If not revert, the trial court's exclusion of contemporaneous reports of abuse will make it more difficult for other abuse victims to prove allegations of abuse and likely deter them. Okay, that's something that could actually work. That's something that could actually work. Could it actually overcome hearsay? Possibly. Yeah, possibly. Because as they say, hearsay is a statement made out of court for the truth of the matter asserted. For the truth of the matter asserted. And so if it's not being offered for its truth, but for some other purpose, then possible. And so, you know, there's some things there. So possible. The trial court wrongly excluded corroborating testimony of Heard's allegations. The court improperly excluded a text exchange in which Depp's agent, his personal assistant, corroborated Heard's allegations of abuse on a flight. A statement made by a party's agent or employee made during the term of agency or employee concerning a matter within the scope of the employment is an exclusion to hearsay. Is it a matter within the scope of his employment? Yeah, she got on the stand. Yeah. JoJo gives 20 memberships to viewers. Yeah, and when she was on the stand, she said like she had reported this stuff right before, right? She said all that, right? They just didn't admit the records. So, I don't, but it could be something the Court of Appeals could potentially bite into. So I'll give them credit where credit's due. I always try to be fair on the stream and look past my own biases as much as one man can. I'm here to be a good legal educator. And in my personal legal opinion, there's something here that kind of makes sense. Now, it's an abuse of discretion standard, but it could be used to rehabilitate Amber on a pretty core issue. So is there enough of it? Is it big enough? Well, it's literally a judgment call. Abuse of discretion is hard, though. So the judge got going for her. But, I want to be a good legal educator and say, there's something here that could potentially work. Maybe it wasn't being offered for truth of the matter asserted. Maybe it was being offered for these other reasons. Possible. Possible. I wouldn't be a very good legal educator if I didn't try to say, there's something here that could potentially work. There's something here potentially worth considering. I don't think it's likely to, but it's like if I didn't highlight it and say, okay, here's some, if I just flat out said this is complete garbage when I didn't think that, I would be a very honest person. I'm an honest person. I try. On May 24th, Duder sent a text message to Heard said, when I told Depp he kicked you, he cried. Duder sent this Heard message after Depp told Duder to smooth whatever issue existed by texting her and telling him whatever she needs to hear. Well, that sounds like lie to her. So I don't know that it really works. The trial court should have admitted this evidence as party opponent. I don't think it's within the scope of employment. I don't think that really works. The trial court improperly excluded the UK judgment. Prior to trial, Heard opposed Depp's motion eliminated to exclude the UK judgment, and during trial, Heard sought to admit the judgment after Depp opened the door of evidence to numerous occasions. While the trial court allowed references to the UK proceeding, it precluded the jury from learning about the outcome. Admitting the UK judgment would have not only been unfairly prejudicial to Depp, would not have been unfairly prejudicial, but exclusion was unfairly prejudicial to Heard. First, the court's decision to allow Depp to refer the UK proceeding without explaining the outcome left the jury with a mistaken impression the outcome of the trial was favorable to Depp, when in fact the UK court had found that Depp had abused her on at least 12 different occasions. Okay. Depp promoted this misperception throughout the trial. While testifying, the court permitted Depp to read into the record the title of the article, Johnny Depp was the victim of abuser Amber Heard, London High Court told. Similarly, Depp's damages expert testified that Depp brought the UK proceeding to clear his name, which served to mislead the jury about the proceedings, about the outcome. Well, if they thought Depp won, then if anything, that would tend to lower his damages in the US, wouldn't it? She also lied in the UK court? Yeah, but you don't know that. You only know that now. Like, you don't know that at the time. You can't. That's the problem. Like, you can't know that she lied. Well, let me put it to you a different way. You can know she lied. The Virginia court can't know that she lied. The Virginia court, in considering the judgment and its admissibility while the evidence is open, can't reach the conclusion Heard lied. You can reach that conclusion now because Johnny Depp won, but that's kind of the problem. It's what they're arguing, right? They excluded something that might have helped her win. So you can't, you can't hoist it by its own petard. You can't justify it by itself. So there's something there. Second is more fully described in Section 3B below. The article precipitated UK proceeding. Depp's decision to file the UK lawsuit, the trial, and significant media attention, and the UK judgment finding Depp had in fact abused Heard undoubtedly negatively impacted his reputation. Nonetheless, this was precluded, presenting the jury with this highly relevant evidence regarding damages. Fair. Because of the prejudicial impact to Heard and giving Depp's false and misleading testimony, trial court erred by excluding evidence of the UK judgment. They have a point. If they didn't know, but if they thought Depp had won, then presumably they would have thought he's already compensated. But I think there's something here. I mean, it is a pretty big factor in damages. One would imagine. It is a pretty significant factor as to damages. Because the question is how much this article harmed Depp, and the degree to which his reputation was already harmed is very relevant in calculating those damages. If his reputation was already 80% harmed, then he can only be harmed another 20%. And, he might build up some reputational difference in between because they weren't back to back. So maybe he reclaimed some of his reputation, but it's still worthy of the calculation. So it's like there's a point here. It doesn't go to the truth of the issue. It doesn't have to, though. It doesn't have to in some ways. The fact that he had been found apparently to be a wife beater by substantial evidence, or whatever the UK's verdict was a harm to his reputation. The incorrectness of that determination is in some ways immaterial to the damages factor, because he can only recover as a matter of law for the damages the Washington Post article created. So whether the UK judgment was correct or not is a little immaterial, because the UK judgment was he's a wife beater, which presumably lowered his reputation, which presumably gave less reputation available to be damaged, which is a worthy calculation in the determinative. So, but she wasn't a part of the UK case. I understand all that. But it doesn't really matter in some ways. That's what I'm trying to tell you. That's why damages were only calculated till judgment came out. Yeah, but you don't know the baseline. That's the problem. Like, you don't know the baseline of damages. Right. Johnny Depp can only recover for the damages the Washington Post article created. So you're correct that you're correct that the jury instructions did tell the jury to only consider damages from the date of publication through something, right? But the problem is you don't know the right number to start from without maybe the UK, right? So again, it's like the same problem. It would be a little bit like me saying, let's suppose we got into a car accident. And I say you can only consider the damages that occurred from a result of this car accident, which is perfectly reasonable. But if the car wasn't in perfect condition to start with, that's kind of relevant in determining how much damage this car accident caused, right? If you were already in a serious car accident, but somehow your car is still driving on the road, which, but okay, like, it doesn't even necessarily have to be a serious car accident. If you were in a car accident of any description that damaged the car, and the car was damaged, then the amount of damage my accident caused is necessarily lessened by the amount of pre-existing damages that existed, right? So you being aware of the damages to the car that existed before my car ever came into contact with your car is relevant. Like if I have pictures of the car or whatever and say, well, this is the condition of the car as it existed before, that's necessarily relevant to calculating damages, right? So his reputation, to the degree it was damaged, whether those damages were warranted or not, it doesn't matter, because he can only recover for the damages this article caused as a matter of law. So any damages he suffered in 2016 as a result of the TRO, he can't recover from. Any damages that the UK paper caused, he can't recover from. He can only recover for these damages. And so to the extent that the jury was not informed about other prior existing damages to his reputation, whether those damages were warranted or not, they existed. The fact that your car is damaged, for example, doesn't mean that you deserve the damage to your car. Maybe you did, maybe you didn't, right? There is damage that pre-existed your car. Maybe you weren't at fault, right? Or maybe you were. It just doesn't matter either way, right? If your car is damaged before my car hits you, whether you were at fault or not, whether you were completely righteous or completely a scumbag, right? Whether or not you deserved the damages to your car by your actions are irrelevant to the fact that damages exist. They exist and they're relevant to the calculation. So I think there's a problem here. No, her recovery is not relevant. Her recovery is not relevant because the question is, for the moment, is Johnny Depp's ability to recover, not Amber Heard's ability to recover. So her recovery or lack thereof is irrelevant. EMC2 says, but they only gave him 10 million of the 50 million he sought. That's true, but we don't know why. We don't know why, right? So, or we potentially don't know why, right? So Johnny Depp says, I was injured to the tune of $50 million. Now, we don't know why the jury reached the conclusion 10. Because the jury was never required to accept his number in the first place, right? It was just a number. I mean, Amber Heard said 100 million on the basis of nothing, right? So Amber Heard's $100 million is just fairy dust sprinkling in the wind. And so is Johnny Depp's number, just sprinkling in the wind. So we don't know why we don't necessarily know why the jury thought 10 million. Maybe they thought 10 million because they were giving discount for damages that already occurred in the past. Or maybe they weren't giving discounts for damages that occurred in the past. They just thought that was all the damages he suffered. Right? We, the jury, think that all the damage you've suffered are limited to $10 million. All the damages as a result of all of Amber Heard, all the damages you've resulted from Amber Heard are $10 million. We think that's what the number is. And maybe that's the reason they gave a discount number. And so to the extent they were not provided with this information and should have been, we don't know if they were discounting for the right reasons or not. Right? We don't know if they said 10 million because that's all the damage that Johnny Depp has ever gotten, or we know that this is all that we don't necessarily know. And that's a problem. And maybe the jury got right by awarding 10 instead of 50, but we can't reach that conclusion, right? The jury has to be provided with the right information. The jury is duty bound. The jury is duty bound to consider only the information that's brought in at court, right? The jury is sworn to consider only the facts and law that are presented in court. So if it's not in court, it doesn't exist. So maybe they would have given the same number with this information anyway. The problem is we don't know, right? The problem is we don't know. Maybe they would have heard all that information and said, yeah, even with all that, we still think 10 million. But we don't know. And the Court of Appeals can't assume it because the jury didn't have it to consider. The Court of Appeals will consider every fact in favor of the verdict. The Court of Appeals will consider the jury considered every piece of evidence in a way that breaks for Depp. So to the extent there's evidence against Depp, the Court of Appeals will kind of go like, well, the jury was entitled to disregard it. So if the evidence had come in anyway and they reached the same number, and Amber said, well, this evidence, though, the Court of Appeals would say, well, the jury had that evidence and they came up with the number, so screw you, right? Every fact breaks in favor of Depp, but the jury never had to consider. So it can't be a fact that they considered and ignored because they didn't consider it at all. So that makes it potentially a problem as to damages. So I think, again, I'm just trying to highlight for you, as always, I'm just trying to highlight for you potential points of strength or potential points that seem like there's something potentially there, right? I give it to you straight. I was certainly very critical of the amicus briefs, as you well know, and even the one that I really liked because I thought it was well written, I thought was crap, right? I thought it was well written crap. I thought it was a great turd polishing exercise. But I didn't really think anything worked. But I still said, well, I thought it was well written. It just does nothing works. And now I'm reading this. I'm like, okay, here's an issue that has some potential. Here's an issue that has some potential. As always, I'm trying to give you my best assessment of where I think weaknesses lie and strengths lie because I want you to best understand where the potentials exist. And I'm like, okay, there's something here on this hearsay argument. Okay. There's something here on this as to damages. Okay. Those kind of make sense. I've already said a lot of these arguments, by the way. And I've already said a lot of these arguments in Amber Heard's brief. I've already said many of them don't make any sense. Because they didn't make any sense. I just try to assess them one at a time. And at some point my microphone is going to die. Let's see if we can reach the end of this before my microphone dies. At least I have to switch to the bad mic. But we'll do as much of this with the good mic as we can. But we're on a time limit. As I'm having to bootstrap this thing. And you guys are asking too many questions. The trial court erred when it precluded Depp from answering a question about the truth of one of the allegedly defamatory statements. Depp alleged that Heard defamed him by falsely writing, in the op-ed, I became a public figure representing domestic abuse. On cross-examination, Heard's counsel sought to ask Depp whether the specific statement was accurate. Despite the fact that Depp was required to prove the falsity of the statement as an essential element of the claim, the trial court precluded him from answering the ground on the grounds it called for a legal conclusion. It does call for a legal conclusion. This was an abuse of discretion. The rule allows testimony on ultimate issue unless the testimony calls for an opinion that constitutes a conclusion of law. Whether a statement of fact is true or false is not a conclusion of law. It might be here. They thought they were going to argue First Amendment. The other attorneys in the amici argued First Amendment. She's arguing other issues. I wouldn't be surprised if the Court of Appeals bounces the amici briefs because it looks like they're trying to evade the work count, and the Court of Appeals is not stupid. I was unable to reach that conclusion before because I didn't have it, and now I do, and so I'm like, yeah, no. Heard clearly was prejudiced by the error. Depp's testimony the statement was accurate, not false, would require an entry of judgment for Heard on that particular claim. Well, on a surface level, but still the implication. And also, the jury could have technically disagreed with it. The trial court erroneously admitted irrelevant and prejudicial instances. At least 2 instances. This better be really good. 2 instances. This better be really good. The trial court admitted irrelevant and unduly prejudicial evidence that had nothing to do with the case, but allowed Depp to attack Heard's character. Evidence that is not relevant is not admissible. Indeed, the relevant evidence may be excluded if its probative value is substantially outweighed. Evidence regarding specific instances of conduct of a witness, when allowed, is normally limited to cross-examination for impeachment. Extrinsic evidence relating to those acts is not allowed. The reading underpinning this rule is that admission of evidence of specific acts and rebuttal evidence would follow, ingest collateral issues in the case which divert the jury's attention. The trial court committed reversible error when it admitted extrinsic evidence of Heard's pledge to donate money to charity. Okay. The trial court committed reversible error when it admitted irrelevant and unfairly prejudicial evidence related to a purely collateral issue, Heard's pledge to donate proceedings of her divorce charity to charity. While a party has significant flexibility in cross-examination of witness and impeachment, the Virginia rules of evidence limit a party's ability to introduce extrinsic evidence to attack a witness's credibility. Specific instances of conduct of a witness may not be used to attack or support credibility, and specific instances of a conduct of a witness may not be proved by extrinsic evidence. Okay. The trial court improperly permitted Depp to include extrinsic evidence about Heard's pledge to donate $7 million to the ACLU and Children's Hospital to attack her character integrity. The pledge, which was announced 2 years prior to publication, was not relevant to Depp's defamation claim and was unduly prejudicial. Indeed, Depp not only used this evidence during cross-examination of Heard, but he introduced the collateral evidence, including witness testimony from representatives of the ACLU and Children's Hospital about the pledge for only one purpose, to prejudice the jury against Heard's and paint her as a liar who only wanted public praise. But didn't Heard testify about the pledge donation on direct? Did Heard testify about the pledge donation to the ACLU on direct examination? Because if so, this argument is dumb. If not, this argument has potential. So my question is, did Heard, on direct examination, when her own lawyers called her to the stand, did Heard testify about her donation pledge to the ACLU Children's Hospital? Was it in their opening? Was it in Heard's counsel's opening? I don't remember that far back. Did Heard's counsel in their opening mention the pledge donation? If so, then yeah, we're kind of toast. Yeah. Didn't Elaine ask her about it? That's why I'm asking. On direct. Not redirect, mind you, but on direct. Yeah. So this argument doesn't work. If they brought up the specific instance first, this argument doesn't work. This trial testimony created a mini trial in which Heard donated what her intent was and whether she intended to remain it. Now, this was relevant to Depp versus Heard. Well, if she testified to it on direct, you have every right to cross-examine it. So, yeah. Elaine asked her on direct, and Elaine's opening, then this argument's done. This argument's done. If Elaine asked about it on direct, this argument's done. Johnny Depp's lawyers may not be able to bring it up in the first instance, but if Heard brought it up in the specific instance, they're allowed to question her about it. It's a valid point of cross-examination. So that argument's just dumb. So if they never mentioned it on their opening, which you guys are saying they did, and they never mentioned direct, which you guys are saying they did, then this argument will work. But if they mentioned it, this argument totally doesn't work. So this argument is dumb. Yeah. The trial court also allowed improper impeachment of Heard when in rebuttal. Depp presented testimony of Beverly Leonard, a police officer purportedly present when Heard was arrested in 2009. The court clearly erred when it admitted this evidence on an entirely collateral issue. During cross-examination, Depp asked Heard about domestic abuse he alleged she engaged in. Heard denied the allegation. This should have been the end of it. However, the court permitted Depp to call Leonard, a former police officer, testified in 2009 she saw Heard acting aggressively toward her then partner, grabbing her partner and pulling her partner's necklace away from her neck. Well, that's like, they didn't bring it up in the first instance. I don't think this works. Permitting forensic evidence of an incident occurred 9 years prior and allowing Depp to paint Heard as a bad person. Well, we didn't have any shortage of that, so I'm not convinced about that one either. All right, guys, I now have to switch microphones. So for all you guys who have been enjoying the honeyed words of this wonderful microphone audio for the last 2 hours and 27 minutes, I apologize, but my phone's battery is going to die because we've had to hijack this and do it the hard way. So we're now going to have to switch to inferior webcam audio. So we will make do, and I apologize in advance that that's what's happening, but that's what's happening now. So yeah. One, two. Check 1, 2. Great. All right. Check 1, 2. All right, fine. That's what we got now, so we'll make that work. All right. The trial court's erroneous evidentiary rulings also left the jury without crucial evidence regarding Depp's reputation, and therefore prevent the jury from accurately assessing any more harm proximately caused by the op-ed. First, the trial court erroneously excluded as hearsay articles relevant to Depp's reputation prior to the publication. The articles, however, were not hearsay as Heard sought not to admit them for the truth of matters asserted, but to show the state of Depp's public reputation prior to publication of the op-ed. Maybe. Second, the trial court excluded relevant evidence related to the UK proceeding, including the Sun article and a UK judgment. At a minimum, the jury should have been permitted to determine whether it was appropriate to apportion any claimed reputational damage between the op-ed and Sun. That's a fair point. That goes to an earlier point they were making, and now they're emphasizing it here. Indeed, the trial court agreed this evidence was relevant, but nevertheless precluded her from introducing the article, judgment, and published media reports regarding the UK proceeding. Similarly, by precluding her from admitting the UK judgment, the jury is left with a false impression about Depp's reputation. Because the UK proceeding had significant corresponding media attention, the world already saw him as a domestic abuser. Nonetheless, the trial court kept the critical information from the jury. Yeah, that's possible. Given Depp's claim that the op-ed caused him significant reputational harm, it was critical that the jury hear relevant information regarding her baseline reputation. Yeah, and then this is a good quote. This is a good statement of the law from Virginia. This is an accurate statement of law. We have said that one with an unblemished reputation is entitled to more damages when subject to defamation than one whose reputation is little hurt, because there's not much hurt to give. Because of the trial court's decision, Heard was prevented from establishing Depp could not have been harmed because he already had a terrible reputation. And he's got a point. Didn't they bring in industry experts to show bad reputation? Maybe they did. Yeah, that would be fair enough. Maybe they brought they could get it in through they could get it in through experts and stuff like that. So maybe the jury was sufficiently informed about it through alternate means. The UK judgment, because they weren't allowed to hear the result, though, is more of a problem. Thus, while jury was allowed to hear testimony of Depp's harm as far back as 2016, the jury was not able to fully assess harm unrelated to op-ed or impact. The judgment found Depp to have committed acts of abuse, including violence. As discussed more below, the impact of this error was compounded by a separate error in permitting Depp to claim damages based on conduct unrelated. I appreciate you being here regardless of the mic. I just always want things to be as good as they can be. And, you know. Now it's just me on screen. I can make the text bigger too. Okay. All this resulted in an indefensible $10 million compensation and $5 million punitive, a verdict that demands reversal. The trial court erred in not dismissing the claim based on the headline for the web version because the evidence established that Heard did not publish it. Okay. The trial court erred by not striking evidence setting aside the jury's verdict based on Depp's failure to prove a required element of the claim that Heard published the challenge headline of the online version of the article, I spoke up against sexual violence and faced our culture's wrath that has to change. Publication by the defendant is an essential element of a claim. That's true. In reviewing a trial court's denial motion to strike or set aside jury verdict, the court considers whether the evidence presented, taken in light most favorable, was sufficient to support. The undisputed evidence established the Washington Post drafted and posted the headline without Heard's knowledge. Okay? Heard testified that she did not notice the headline when she tweeted the link, which the jury was entitled to disregard. Thus, there's no evidence that Heard published the headline. The tweet itself is evidence because the headline is in the tweet. She says she didn't see it, but, well, it's up to the jury. Indeed, Depp effectively conceded this, his theory being that Heard republished the headline when she later retweeted a hyperlink. But courts have constantly held that providing a hyperlink does not constitute republication, even a tweet that favorably references the article. That is not what the case law says. The trial court erred in two ways. First, the trial court's refusal to exclude the headline from evidence led to the introduction of irrelevant and prejudicial evidence and arguments. Yeah, it was also a retweet. That's right. It was a retweet, not a tweet. So, yeah, she retweeted the article that had the headline in it rather than merely copying the hyperlink. That's right. It was a retweet. So that fact also matters. Because if she had merely put the URL in without reading the article, one wonders how she got a copy of the URL, but she retweeted, which means that she saw the thing she was retweeting to, or the jury could conclude it. Yeah, good point. Good point. Thus, the trial court erred in two ways. First, the trial court's refusal to exclude the headline from evidence led to the introduction of irrelevant and prejudicial evidence and arguments about whether Depp had committed sexual violence against Heard. As opposed to other forms of abuse, thus infecting the jury's verdict as a whole. I don't think this works. Secondly, because the jury awarded 10.35 for all three challenge statements together, there's no way to know how much the statement is attributable to the headline. She published it. That doesn't work. How much more of this do I have to read? Is it a lot? It doesn't look like a lot. The scroll bar is getting towards the end. My voice is giving out a little bit, but we'll keep going. Okay, just give me a second. All right. Yeah, she quote tweeted, adding, "I published this op-ed." Yeah, that too. Yeah, that too. Yeah, fair point. What page am I on? I'm not sure. The trial court refused Hurd's proposed jury instruction, which set forth communicative intent prong of actual malice that Depp was required to prove by clear and convincing evidence. As a result, to the instructions given to the jury on actual malice were missing this critical component, and new trial is required. The trial court gave two instructions defining actual malice. Instruction AA addressed only the first prong of actual malice. Instruction BB correctly clarified that actual malice is not established by ill will or hatred. $49 apparently. At least the marked pages. How would like to go? Okay. Hurd's proposed jury instruction, which the trial court refused, to address the communicative intent prong of actual malice that must be established when, as here, the claim for defamation by implication. The jury should be instructed that also must find by clear and convincing evidence that Ms. Hurd either intended to communicate defamatory implication or knew of the defamatory intent and was reckless in regard. That's fine. When considering whether a jury instruction was properly refused, the evidence is viewed in light most favorable to the instruction. If the proffered instruction finds any support in credible evidence, its refusal is reversible order. As explained above, Depp presented no evidence that Hurd either intended to communicate the op-ed that he engaged in domestic abuse or knew of a defamatory meaning. To the contrary, evidence shows that Hurd made significant efforts to eliminate such innuendo. The trial court's improper refusal demands retrial. That has some potential to go somewhere. Because I believe Virginia law is clear that the intent or the intended meaning must be subjective as well. So I think maybe there's something there too. The jury's verdicts are inherently and irrecoverably inconsistent. No, they're not. Jury verdicts that are irrecoverably inconsistent cannot stand, at least according to Virginia. If there's no reasonable way to harmonize the verdicts, a new trial should be granted. They can be harmonized. To reach the verdict against Hurd on Depp claims, the jury necessarily found that Hurd had not been abused, and she knowingly lied in stating she had abused her. And at the same time, to reach a verdict in favor of Hurd, one of her own defamation claims, the jury necessarily found they did not lie about being a victim of domestic abuse. That's not what that means. As Depp argued the case, this case involves two essentially mirror image defamation claims asserted by the only two people who truly know whether the statements are true or false. If Mr. Depp did not abuse Ms. Hurd, she indisputably knew the claims that did false. Ms. Depp did abuse Ms. Hurd, then he knows the statements are false. Thus, the trial court erred and declined to set aside the jury verdict on the grounds inherently and irreconcilably inconsistent. No, it's not. Waldman's statement was much more specific, so they could have found it. They could have found it false for reasons other than that, which seems like absurd to come up with $2 million for it, but they're not irreconcilable. The jury damage is excessive. Virginia Supreme Court has instructed that courts have a duty to correct a verdict that appears to be plainly unfair and will result in miscarriage of justice. Setting aside a jury verdict is necessary when the award is so excessive it shocks conscience or creates an impression that the jury was influenced by passion, corruption, or prejudice, when the jury has misconceived or misunderstood the facts, or the award is so out of proportion the injuries suffered as justice is not the product of fair and impartial. I think there was plenty of evidence to support a $10 million verdict. There was plenty of evidence to support more than that, in my opinion. But my opinion isn't what matters here. The jury's opinion is what matters, and they said $10 million, and there's enough evidence to support that number. So, Depp's damages are limited to a narrow period between the publication of the op-ed and the issuance of the UK judgment. Issuance of the UK judgment. Did I get this wrong? I might have to revise a lot of what I said earlier. Okay. Let me think about this and whether I have to revise a substantial chunk of what I said earlier, because I might have had the timing wrong. Let me think about this for a second. Does anyone happen to remember the publication date of the Sun's newspaper's article in chat? Does anyone happen to remember when that happened? When the Sun newspaper printed its article, or can anyone look it up as I consider whether or not I have to revise some stuff? Early 2018. Okay. April 2018. It was after the UK case. That's not possible. 27th of April 2018. All right. Okay, then I think I have to revise and reverse myself on a lot of what I was saying because I think I had the timing wrong. If we're suing from the date of the publication op-ed to the issuance of the UK judgment, then the decision of the UK itself can't be relevant. So therefore, exclusion of the UK judgment is necessarily correct. So on the Sun's website, April 27, 2018. Okay. So yeah. So I have to reverse what I said earlier about the UK judgment because it is now no longer relevant to the assessment of damages. It can't be. Because we're only assessing damages from before the judgment occurred. So it can't be relevant to damages, assuming the jury followed the instructions, which is an assumption as a matter of law. I told you the judge took care of the timing. Well, David, yeah, maybe I just misunderstood something, and I'm correcting myself. And like, okay, so I misunderstood something. I made a mistake. I read something. I'm like, I made a mistake. Let me correct the mistake. What more do you want from me, David? I'm doing my best over here. I'm sorry. I revised my opinion in light of new evidence. Okay. All right. So now the exclusion of the UK judgment is not only proper, it's necessary. So all that stuff I said earlier, you can reverse. So yeah, fair enough. So that takes a huge chunk out of their argument. So now what are you left with? If you take away the UK judgment, there's not a lot of press about it. So now you're left with industry papers, but you had experts testifying about that. So yeah, so never mind. Take what I said earlier, strike it. You know, one of the things that's nice about being a judge, one of the things that's nice about being a trial judge is you're not bound by your own prior decisions. So one of the nice things about being a trial judge is you're not bound by your own prior decisions. So if you realize you got something wrong, you can say, wait a second, I know I said X before, but I was wrong. Now I'm saying Y. I'm sorry, panel, I made a mistake. So, okay. Yeah. All right. Fair enough. Depp failed to provide any pecuniary damages. I put myself in this position of a judge, and when presented with new evidence, I create revised legal opinions. This is hopefully the hallmark of a good judge. To err is human. To correct shows wisdom, hopefully, or something like that. Um, the jury's verdict of $10 million in compensation damages is grossly disproportionate to any reputational harm the op-ed could have caused during that small window. No soup for me, Paul? Aw, but I wanted soup. Damn it. First, there's no evidence upon which a jury could rely to determine that Depp suffered any pecuniary loss because of the op-ed. Depp principally claimed they lost the role in Pirates 6 because of the op-ed. But the trial court does not support such a conclusion. As an initial matter, Depp failed to establish they actually had the opportunity to act in Pirates 6 and then lost it. He did not have a written contract for the film. Even before the op-ed was published, the media reported that Depp would not be in the film, and his agent testified that Disney was non-committal about Depp role. At any rate, Depp testified he would not agree to play a role in Pirates 6, even for the $300 million and $1 million in packets. Well, yeah, at this point now, yes, he testified now he wouldn't do it. At the time, maybe less so. Depp also did not prove he lost the opportunity to appear in Pirate 6 because of the op-ed. The corporate representative testified no decision maker within the company had ever said they would not cast Depp because of the op-ed. Nor did Depp present any evidence he lost any other opportunities because of the op-ed. That's not what we heard from some of the experts. For example, Depp still has an endorsement deal with Dior. Wow. Given that the jury could not award Depp for any pecuniary loss based on the evidence of trial, sure. And Depp never sought emotional distress damages, which was good for him because it didn't allow it didn't create the same problem that it did for Amber Heard, because now we like to bring her mental state becomes an issue because she brought psychological damages into play, which allowed for, so him not bringing psychological damages into play turned out to be a pretty smart move. A jury must award damages that only from the defendant wrong and not from other cases. The trial court improperly, Amber Heard wants you to believe that she's worth the same as Momoa. Yeah, that's a little bit hard of a pill to swallow. The trial court improperly admitted evidence that encourages the jury to award damages for conduct unrelated to the op-ed, specifically evidence of reputational harm suffering from the restraining order. Well, it was relevant because she said 2 years ago, and now we have to talk about what happened 2 years ago. So you kind of brought that into the fold, so it's relevant. Like, you can't get damages for it as such, but you brought it into light, and so you're republishing, and Depp's trial was a theme for a plea of the jury as a result of the restraining order. These sentiments permeated the entire trial. According to Depp, when Heard obtained the restraining order, he lost nothing less than anything. Everything. That's not what he said. That's not what he said. I think I'm pretty sure that he was asked, what is your result from a result of all this stuff? Nothing less than everything. I don't think he said specifically about the restraining order. I don't remember that being the phraseology. I know it was a couple months ago, but I don't think it's what he said. He explained that when the allegations were rapidly soaking, telling people I was drunk and cocaine-fueled menace who beat women, suddenly in my 50s, you're done. In fact, Depp's testimony began with an explanation of why he brought this case. About 6 years ago, because that would have been 2 years before the publication of the article, Heard made some quite heinous and disturbing, brought these certain criminal acts against me that were not based in any specifics of truth. Depp also testified that the public became aware of the restraining order. The bad news about him was multiplying throughout the media, through social media as well. Even Depp's expert, Doug Bana, who Depp paid to retain the analyze of the impact on his reputation, could not say that Depp's reputation or public image were affected by the op-eds as opposed to evidence in 2016. There was some evidence that would allow the jury to draw those conclusions. Because Depp improperly was allowed to suggest the jury could award damages based on the statement, because the jury was not informed of the outcome of the UK proceeding, which now I understand why, because it was legally irrelevant. it was irrelevant because they didn't sue for they sued for damages up to the point of the outcome. So the outcome is legally irrelevant. So I assume that was a brilliant trial tactic by Depp's team, and if so, more power to them. So rather than being a fatal error, the court was absolutely right. Time matters sometimes. Sometimes time and dates and things matter. And sometimes when the time and dates and stuff happen in certain orders, it creates different conclusions, as I've learned during the stream. Depp was improperly allowed so juries could award damages based on statements. Juries not found informed because they shouldn't have been. The jury's damage was wholly out of proportion to reputable damage they actually could have sustained as an op-ed. I don't think that's true based on the evidence. It's clear from the size of compensation damages jury intended to award damages not for the op-ed, but for all negative publicity. That is not clear from the nature of the evidence. That's an impermissible basis damage. All reasonable inferences go in favor of the verdict. There's more than enough evidence to support $10 million, in my opinion. Conclusion: for foregoing reasons, we support reverse remand. Okay, so after being corrected, is there anything left? Oh, David Axelrod is on this brief. Ooh, how fun and exciting. J. Ward Brown and David Axelrod. And fun and exciting. All right, so let's look at the table of contents and see if there's anything left. All right, let's see what we got on the table of contents here. All right, trial court should have been dismissed for form nonconvenience. No. Defamation's claim arose outside Virginia. The citations to the law are not good. Virginia was completely inconvenient. No. Trial should dismiss Depp's claims because the challenge statements are not actual opinion. No. The trial court should dismiss Depp's claims because the challenge statements are not reasonably capable of conveying a defamatory implication as a matter of law. No. Trial court should dismiss Depp's claims because the doctrine of issue preclusion prevents relitigation. No. Depp failed to prove by clear and convincing evidence that Heard was aware of and intended to communicate the implication. No. Depp failed to prove by clear and convincing evidence that he knew the alleged implication when abused was false or sustained entertaining serious doubts. No. The trial court made numerous evidentiary errors that severely prejudiced Heard. The trial court erred by excluding evidence of Depp's abuse and Heard's state of mind. Heard's reports of abuse to medical providers plainly were admissible. Maybe. The trial court wrongly excluded corroborating testimony of Heard's allegations. Maybe. So these are still viable, I think. Trial court improperly excluded the UK judgment after much consultation and reevaluation. No. Trial court erred when preclude Depp from answering the question about the truth of one of the alleged demonstrations. Even if so, it's not enough. Trial court erroneously admitted irrelevant and prejudicial evidence. No. The trial court committed reversible error when it admitted extrinsic evidence of Heard's pledge to donate. No, because she brought it up first. The trial court admitted reversible error when admitted extrinsic evidence of Heard's alleged domestic abuse. Even if true, it's not enough. The court's evidentiary ruling occurs to George Ward damages. Unrelated op-ed? No. Trial court erred by not dismissing the claim on the op-ed for the web version because Heard did not publish it? No. Trial court improperly instructed jury on actual malice? Maybe. Jury verdicts are inconsistent? No. And the award is excessive? No. So I got 3 maybes here. I'd be interested to see what the rest of LawTube has to say about the hearsay stuff, because I'm open to the possibility I'm missing something dramatic. But this assignment of error 5, But there's also the possibility that they were able to get it in other ways because Heard was able to testify about doing those stuff. She just wasn't allowed to bring in the reports themselves. So maybe this doesn't matter. But there's still something here that's caught my interest. And the fact that they weren't explicitly told that they had to find that Amber Heard intended the implication meaning or was aware of it, maybe. But if it's not a model instruction, which it doesn't seem to be, then I doubt it. So there's not nothing here. There's not nothing here. Excuse me. By the way, congratulations to the U.S. for advancing the World Cup. Kick ass. So I'd be interested to hear from your guys. One second. I'd be interested to hear from you guys what other law tubers thought about the hearsay arguments. Did anyone think that they had any merit? And what did they have to say? Because I'd be interested to hear some other opinions from my colleagues. Because I'm always willing to consider their opinion. So I'll look in chat to see what's happening today and see what you guys have to say about other people who've covered this. Legal Byte said, yeah, but Amber was able to testify about the same thing. That's fair. Therapy isn't medical. I'm not sure if that's true. Some say no and some say maybe. You haven't watched? You watched me first. I appreciate that. Legal Bytes point out her saying that she wasn't abused is the same as the doctor diagnosing. That's a fair point. Yeah, most people doesn't think she has a chance. Yeah, I think her odds are not great. Her odds are not great, but it's something that caught my eye that I was interested in further analysis on. Emily D. Baker had a similar assessment. She testified, though, we're lacking injury records. They were her own words. Yeah. So maybe it doesn't matter because if Amber Heard was allowed to testify about it, then court said the therapy is self-reporting. Yeah, but statements made for the purpose of a diagnosis, which is an exception, is also corroboration to rebut, to rebuild, take character, which is also an exception. So what happened to having a good microphone? The battery on my iPhone ran out. I was hijacking my iPhone's lavalier mic, which unfortunately I can't plug into my laptop, and my iPhone died. So we had it for 2.5 hours. It was a good ride. If this appeal gets denied, can she do it again? Sure, she can always appeal to the Virginia Supreme Court. She can ask them for review. Therapy is not factual, it's a person's perceptions. Nah. Notes are not medical records. I'm not sure if that's true. If that's true as a matter of Virginia law, if psychotherapist notes are not medical records, for the purpose of this under Virginia law, then fine. That would solve it. But I'm not sure that's true in the abstract. If she brought a therapist, would that stop it from being hearsay? No. It's the same problem. I'm waiting for the resident appellate applicant judge, Andrea Burkhart, to look at it. Respect. Andrea Burkhart is, in my opinion, the most underrated of the law tubers. She's incredibly smart and she is incredibly well informed and she does her research. She is the law tuber I would most want to work with in the real world because I think our skills would very much complement each other. And she is the most underrated. She is someone that is very much worthy of consideration. This, of course, in no way precludes me from disagreeing with her from time to time because, hell, I disagree with Supreme Court justices I agree with from time to time, and I agree with ones I disagree that I otherwise disagree with from time to time. So it'd be odd if we always came out exactly the same. But she's an incredibly smart cookie. I disagree with myself every now and again. This is also true. Yeah. Yeah, Andrea is amazing. He's to understand. She's focused and fair. Yeah. Mary says, so if I lie to a therapist to induce me to give a favorable diagnosis, it can be credible. Well, it is a statement made for the purpose of diagnosis not related to litigation. So admissibility is the key question. I disagree with the unanimous Supreme Court from time to time. I sure do. I sure do. I disagree with the unanimous Supreme Court from time to time. It's true. Yeah. All right. Well, when Andrea covers it, I'll be interested to see what she has to say for sure. Because she's a smart cookie. Be also interested to see what Rob has to say since he's a Virginia practicing lawyer. I'm Virginia admitted, but this is never my field of law, and I'd be interested to hear what he has to say on the subject. If I need to do a massive revision, I can always make another video about it later. Be like, okay, here's a rata for what I said earlier. Let me see if I can get access to my super chats so I can read them before I sign off. Will the computer cooperate with me? Will the computer cooperate? Will I be able to get to the super chats? Find out next on this episode of Dragon Ball Z. Wait and you 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 wait. Will it load? We got some of it. I think we got it. All right, let's try to find today's date and read some super chats as a way of thanking you guys. If it wants to scroll, will it scroll? This is the new Will It blend. That's what's going on. November 26th, 27th, 29th. Why are only 3 chats? Why are there only 3 super chats in the database? I hate my life. The Heavy said at the end, please tell me this appeal will not be won. It probably won't. Shelly said for the hat fund, thank you. And Tony Neve said, hey, Kurt, possibly good trial to file would be this Border Patrol serial case. And those are all the things that the bot captured. Well, that sucks. Because everyone gave gift subs instead? That's why, then fair enough. All right, well, I tried. I'm going to sign off for now. I need a drink and I need some dinner and stuff like that. But this has been a lot of fun. I hope you had a lot of fun. As always, it was been a good time. A good time was had by all. Andrea did this brief as trash. She was talking about the amici briefs, and I largely concur with her. I'm not sure the degree to which we would split on the because I only read the one. She only did the one brief that I thought was trash. I'm not sure the degree to which she would share my sentiment of the other brief was generally well written, although obviously legally wrong. And I'd be interested to see a lot what she has to say about this. But I'm going to sign off for now. Remember to do all the YouTube things, like, comment, subscribe, all the good stuff. I've been Uncivil Law. I hope you have a good one. Until later, my friends, I hope all's well. Cheers, my friends, and goodbye.